say, but I'm going to say it because that's what I do. And if you can hear me, please give me a thumbs up in the chat. Can you hear me? Can you hear me? It's a reason why I was able to catch this paperwork today. I was so frustrated I couldn't even stay at work. So please hit that like button, hit that like button. Let me see if I have any cold water up in this piece. If you can hear me, like me up, like me up. Oh Lord, the little refrigerator. Can y'all hear me? Okay, y'all can hear me? The judge has spoken on all that paperwork. Whew. And y'all can hear me? I'm waiting on y'all. I mean, I can check it myself. Hold on. Y'all can hear me? Can I get the thumbs up, please? Can I get the thumbs up? I'm so, mm, I'm so motherfucking tired of being nice. I don't know what to do. Hold on. Can I hear myself? Yeah. Being nice. I don't know what to do. So let me say this. Oh, okay. I got Queen Christy. Queen, I might have to turn you into a whisperer. How you know I wasn't looking up? Oh shit. I need that laugh. Let me go on and greet you people. My people. What's good with it, Love Spare? You was first. Whoa. Candy Jones. What's good with it? Shout hey, shout hey. Mo, hey. Hey, yeah, Aunt Jay, that's right. That's when I know you talking to me. You calling this Angie. You ain't calling no other Angie in the family but me. Oh wow, I like that. Hey, Candy Jones, Queen, what's good with it? Nobody's fool, nobody's fool. DJ Amazing, Jennifer. Nobody can hear you over that loud music. It was loud. Oh no. Hey, peace in the puzzle. Shalom. Yeah. I don't. Assalamu alaikum. I don't know if that's. I don't know if that's in the same situation. But greetings. Guten Tag. Hola. Let's see. I think I got Jennifer. Dolores, hello, honey. SM. Yes. I almost called you S&M. You might want to, I don't know. You might want to do something about that. I almost called you S&M. So listen, y'all. Listen. I tell you. I be wrestling with shit. I be really, really I don't know. I just have to say something. I just have to say something. There's a reason why my mother's side, a lot of them come to me for certain things, right? Or have me ahead of certain things. And definitely on my dad's side, um, he had me in charge of certain things, whatever. You know, being at certain of his locations and things of that nature, doing just a lot of, I'll say, administrative type things. Shit, you got to watch what you say around here, huh? But I'm legit, right? And and unfortunately, I have been able to do five or six, seven things, honey. From one location, here, there, everywhere, right? And And today, like I said, I was still in training for some things, right? I was so upset because things stay on my head. I hate unresolved shit. And I don't like nobody fucking with me that I'm not fucking with. I never say that I'm an angel. That's not what I'm saying. I don't go fuck with nobody that's not fucking with me, and I don't allow nobody, you know, just to get some shit started. And these motherfuckers do all this shit with all this beefing and whatever. That is the culture around here on YouTube. I neglect to be a part of that. All right, I have better shit to do. And you can attack a motherfucker, some of these raggedy motherfuckers around here with their truth and be done with it. I will before I was all, about disclosures and with me because I'm thinking I'm talking to, just normal, regular, everyday people. Ain't no big secrets to keep or whatever. It's the shit that you keep, secrets or whatever. I mean, it'd be a matter of something, serious or whatever. Not no, ridiculous bullshit or whatever. I mean, I like to talk about life. In life, that requires you to disclose some shit about your ass or others or your life experiences and shit like that, right? And you try to come on to be, I'm a friendly type person. Now, don't get on my bad side, because I will, chop your ass up. Well, I'm a friendly type person, and I like, a lot of these people on here come on and want you to accept what they say. All right. And a lot of people here will give you a dose of them in whatever way they give it to you. However they give it to you, they'll give you a dose of them or whatever. That's fine too. I have to do mine the way I like to do mine, whatever. I like other people to say something. A lot of these people brag and boast and shit like that. No, I have other people that will tell, that will sing my praises. I don't do self compliments. I don't do bragging and boasting and shit like that. That's just not my MO. I find that to be, tasteless and stupid. You compliment yourself. Of course, you think you all that. Some people do. I don't. I deal with the real. You know what I'm saying? It is what it is. But with that being, and I don't know why I went on that because I'm all over the place. But and today I was at work training, and I saw where you go into your profile and whatever, and it shows that I have been training people and teaching. It's actually two different things, right? Training, usually like you train somebody on the job or whatever, and teaching since 2000. I've been training and teaching on that same system that feeds Pacer since 2000. All kinds of stuff I put in there. And anytime you dealing with, if you ever worked for the federal government or did contracts for the federal, or however, you have to deal with their systems or whatever. It pretty much, remains there. And, you have shit all over the system or whatever. And I was like, wow, that's been over 20 years, right? So, when I told them, because now right now I'm a rook. I don't answer to nobody or whatever, but I got to train like with the regular people. I'm not over nobody anymore, anything like that. I'm just a rook. I'm just doing a contract. I'm just a rook. And so when I went and told the person, and this I got to get used to that, telling somebody I got to leave. They were like, Oh, okay, not a problem. They like, girl, we ain't worried about that. And I was worried about how I would look on my record. And then I looked in that system and I was like, damn, my log said I've been fucking around this system since 2000, right? So I'm like, yeah, okay, yes, now that's crazy. I'm sorry, I just got something from work, something I was working on to see that was completed. Wait a minute. Okay, all right, okay. So and I like to be, there till I get when I get my stuff back that I was, completed, that I completed. But when you got something weighing on your motherfucking mind and shit, so much that you got to motherfucking leave work, that pisses me off. Even though I'm still get paid for it, that pisses me off. Cause it's YouTube unnecessary shit. I don't want nobody lying on me and saying I done something, whatever, and nobody even questioned and said, "Well, can we see the proof?" Well, what we don't take your word for it just because we don't like her or whatever. And that to me is just some bullshit. Even if I don't like a motherfucker, I like to know that what you saying about a person is the truth. And unfortunately, and I hope I'm not talking about nobody here. And like I always say, if it doesn't apply to you, then don't apply it to you. But we have a whole bunch of weak ass people, specifically weak ass women, that babysit these niggas, believe anything the motherfucker say, whatever, and just run with it. Don't even have the proof, don't see nothing, and just go with the shit. I don't like shit like that. I really don't, and that's why I really like it. That's why I kind of disengage from people like that and bullshit. I don't need all of that shit to keep nobody coming over here and listen to me. But like I say, I would motherfucking go live or whatever. I don't give a fuck who in here. Because when I click off, I know it's one in the books. You get to it when you want to. I don't have to do all of that. Because that's when you know if you have substance and or intelligence to be able to conduct the motherfucking goddamn live and shit and not fabricate or come up with some bullshit and some drama and all that type of shit just to hold on. God damn, we got another. I'm sorry. See, I was okay. I'm sorry. Hold on. What this say now? Hold on. Hold on. Okay. Okay. I don't give a fuck about that anyway. So anyway, and so people just go with motherfucking bullshit. I've seen it all. I've seen these women go. I mean, would tear your head off. But these motherfucking niggas are trying to support or attack people on behalf of these motherfucking niggas. Many of them that you don't even motherfucking know. And largely, these niggas won't do the same for your motherfucking ass. I don't understand how that works. And I get it, right? And there are a lot of weak individuals, male and female. That I don't fall in that category. You know, I'm damn sure not finna be no motherfucking attack dog for Nam nigga. Or, you know, just bullshit. And it's crazy. And especially I done seen some shit where you can sit up here and have a damn near perfect record. Then you have somebody else record always jacked up, chock full of lies and bullshit, just stupid ass shit. And them motherfuckers will take the side of them, won't even ask them for no proof of nothing, and then assume that the motherfucker that be pretty much on the straight and narrow, ask them, to prove and attack their ass. Like, I don't even know how that works. And the only thing I can say is it's a lot of desperate ass people. You got people that's desperate for men, friends, women, and all that type of shit. Again, I don't fall in that category. So maybe my behavior justifies that. That's not something I have to do. I'm not with all that bullshit. I'm really not. You should operate around this motherfucker as if any one of these motherfuckers would double cross your motherfucking ass. So you better be prepared. And it's really fucking disturbing. And I'm so glad I operate solo dolo. Because the attachment to people like that, I can't do it. Because I'll be looking at you like, what the fuck is going on? I done seen, situations where, women jumping on other men for another motherfucking man. And I'm not talking about no situation this has happened on here. But I'm talking about what I've seen like as a street fight. Shit like that. I don't get it. But then they want to sit around here and go with that, women and support the women and shit like that. And this is crazy. If you're a woman, you should be into supporting women. Straight up and down. I'm not talking about no argument where everybody tearing down each other. I'm not talking about that. I'm talking about just some initial bullshit when shit jump off initial. If you're into supporting women, that's what you should be into, supporting women. And you can actually do two at the same time. You can support both women and both men. But to me, I'm support women and men that are decent. Not nobody full of that bullshit. And sometimes you got to ask yourself, where is it coming from? Sometimes with this bullshit that goes on around here, you need to ask yourself, well, what's the origin? How I got started? What happened? And nobody does that. You just, and it's just some weak ass shit. It's like a lot of thirsty bitches. All kinds of shit. And it really turns my motherfucking stomach. And I'm asking you politely, leave that shit away from me. I will, and depending on how I'm feeling, I will call that shit out. That's not what I do. And especially if you coming at me with it, that ain't gonna work out. But and how I defend myself, if somebody starts some shit with me, don't get mad about how I defend myself. Don't get mad. Don't call me no double crosser. Don't call me this, that, and whatever. Because I didn't ask to be put in that situation. Now, I'm not in the motherfucking mood. I'm going to tell you right now, I'm not going to be in the mood today, tomorrow, Saturday, Sunday, or Monday. I'm telling you that right now. And I don't want to hear shit. Because I'm out of time for this motherfucking bullshit. You got motherfucking stupid motherfuckers want to drag you into bullshit. And this is the classic motherfucking shit these motherfuckers use. They come up with some bullshit as oh they was talking about me, whatever. Nobody say shit about none of these motherfuckers. For what? Do you know I got probably 20 motherfuckers that's worth something that I could talk about? It's about 5 or 6 motherfuckers that's worth something that I could talk about on here. That's most likely who I'm gonna talk about. I'm not gonna talk about nobody that I feel they ain't worth shit. I don't give a damn how they feel about themselves. To me, you ain't worth a motherfucker. They like to play these motherfucking games and all this bullshit. You got motherfuckers that lie and put shit out there, then they don't even do their own motherfucking shit. They go and try to use the shit somebody else done put out, some other dumb motherfucker done put out, and then try to fucking piggyback off that. They look more stupid. So when I tear your ass up, now here you go. You want to cry. Like, I don't want to be involved in no motherfucking bullshit. I know I have been. I don't want to be involved in no motherfucking bullshit. And I definitely don't be the starter of no shit. Only thing it is, I will address, back then, let me change it. I will address slick motherfucking comments and all that type of shit. Because I figure you should be able to say some shit in a different manner. Therefore, when somebody responds, you're getting a different type of response. But if you say some slick shit, that's exactly what it's going to be. Hold on, let me see. Now, who is this? Wait a minute, y'all. Hold on. I'm sorry. So this is what happened when I leave work early. Okay, hold on. See, something else might have been undropped too. Wait a minute. Let me grab that real quick. Let me see what it is. Okay, no, it's another attorney making an appearance for the USA. Hold on. Why is they making an attorney appearance in New York? Hold on for a minute. Hold on, y'all. Let's be nosy. Wait a minute. So, and I don't like all this shit. I really don't. And I mean, I would prefer so nobody don't get it motherfucking twisted. Don't reference me on your motherfucking channels. Don't reference nothing about me on your motherfucking channels or chat. By name, directly, indirectly, or whatever. If I'm not fucking with you, you shouldn't be referencing me for nothing. I don't even come on here like that. When I come on here, I'm coming on here to do one motherfucking thing and to get the fuck off. I do not. Okay, that's 286. Hold on. Wait a minute. We got something. We got action in New York. Hold on. Like I said, the trial may be over, but the case is not over in New York. So let me see. We got action New York. Somebody is joining the USA team in New York, and we got a writ. We got a writ, y'all. Motion for writ. Hold on. We got something else to read in New York. Let's see. Oh, we got the Bureau of Prison shit for New York. Okay. All right. Okay. So y'all gonna have to hit that like button. I'll be talking some shit. So y'all hit that like button. Y'all see what them likes at. I'm not fucking around for the next 5 days. I'm not fucking around. I don't want to hear shit. I go out. Let me go check this motherfucking like button. I need about 7 more likes, please. Please, I'm not fucking around. I'm not fucking around. I don't give a fuck who you are. I'm not fucking around. You know, I have a lot on my motherfucking plate. Fucking around with you motherfuckers on this bitch that I don't even motherfucking know is not even on the plate. It's not on the table. It's not even on the floor. It's outside in the grass, crawling around with the rest of the low belly ass caterpillars. I'm not fucking around. These people consciously keep your ass in bullshit because they got a motherfucking fucked up, feeble motherfucking mind. And if you think I'm motherfucking playing, I'll spend the all motherfucking night. I'm still got training materials to do for something else. I got shit to check on from my father and them side. Houses and motherfucking clean up with all kinds of bullshit. That shit um falls on me. So I don't have time for no bullshit. I'm not fucking around. Y'all sit up here with that bullshit fucking with people for no motherfucking reason. Because everybody in their fucking feelings about something or other, here they come with the YouTube shit. Not me. No more. I swear for God. If you think I'm lying, I don't give a fuck who it is. The next motherfucker. The next. Y'all, I'm trying to tell you. Make sure I listed those two links on that those channels I need y'all to subscribe to. I swear for God, the next motherfucker that fucks with me, that I ain't fucking with, I swear for God. That's all I'm gonna say. And if you wonder if I'm talking about any of you motherfuckers, talk to everybody. I don't want to hear a motherfucking thing. I don't want to hear no bad boy, no bad girl talk the next motherfucker. Cause I'm sick of being accused for some motherfucking bullshit. And here we go with the goddamn shit. And then when you come out the motherfucking take care of the motherfucking bush and straighten it out, oh, you done something wrong. No. You a low life dirty motherfucker. I'ma handle you as such. That's what it's gonna be. And that's the only thing I'm a motherfucking say. Kiss my ass. Now let me read this about this BOP shit. That's a hotbed issue. Let me get that up. Other than that, how y'all doing today? Thank you, Par. And there's a lot of motherfuckers that try to destroy your channels and this, that, and the third, whatever. Here's the thing. One thing y'all ain't learned about me yet. See, I'm smart enough to let you do the work for me. If you get your ass on up off my life, out my goddamn channel, out of my motherfucking way, you do shit to where you get your ass on and you know you don't cross the line where you can't cross back, you're doing the job for me. I'm sitting back laughing. I'll take the hit. But let me tell you something. What that lady name? That lady made a song called Blame It On Me. You can say I was the worst motherfucker in the world. As long as you say it is over and you get the fuck on out my goddamn life. Out my motherfucking way. It has happened so many times. And like I say, if I deem that you was somebody I want to be fucked up with, then I will, you know what? I will meet your motherfucking ass, motherfucking give you, I'll do the 51%. Because I figure, it could be a one-off. Other than that, I don't give a fuck. Get your ass on. And stay gone. Now, let's read about this BOP shit, child. All right, we got the United States of America versus Robert Sylvester Kelly. All right, dear Judge Donnelly, the government writes to respectfully request that the court sign the enclosed proposed order directing the Bureau of Prisons, BOP, to turn over the restrained funds held in the inmate trust account of defendant R. Robert Sylvester Kelly. Oh, remember, this is something different. They gonna take his money, y'all. Now, remember I told y'all that there he will get a notice when they will start collapsing, taking his money, right, from his account at the jail. It wasn't something automatic. All them people lied and saying, like, oh, you send the money directly to him, they're going to take his money. No, you have to have some type of order. And I told y'all that. Well, I guess this is what it is. All right, this ain't the BOP Larry shit. I should have known that because this is coming out of New York, but I didn't know what it was. So this is, they taking his money. Team Cal, they finna take his money. All right, y'all, listen up. So it said to turn over the restrained funds held in the inmate trust account of defendant Robert Sylvester Kelly to the clerk of court for deposit into an interest-bearing account pending a determination as to the amount and applicability of a restitution judgment. So, okay, well, let me keep reading. The proposed order further provides that to the extent restitution is not imposed or the amount held in the interest-bearing account exceeds the amount of restitution and special assessments imposed, the balance in the interest-bearing account should be applied to the outstanding court-ordered fine. As of this writing, the request of the government, the BOP has restrained $27,828.24 of the funds that have been deposited into the defendant's trust account. I'm going to say now, as this writing, at the request of the government, the BOP has restrained $27,828.24 of the funds that have been deposited into the defendant's trust account. Sylvia, now you got an amount to work with. It's $27,000, $27,828.24. Now you got an amount. Now you can work on that. Y'all can work on that now. Background. Following a 5-week trial, the defendant was convicted of 1 count of racketeering in violation of 18 U.S.C. sections 1962C and 1963, and 8 counts of sex trafficking in violation of the Mann Act, 18 U.S.C. 2421. Reference. Defendant was incarcerated pending trial in MDC, Brooklyn. On June 29, 2022, the court sentenced the defendant to serve 30 years in custody, pay a $100,000 fine and $900 special assessment, and 40 grand Justice for Trafficking Victims Act at 3 and 7. Okay. The court did not impose a payment plan, making these monetary penalties due immediately. Whoa. Reference. A hearing on the restitution to be imposed on the defendant is presently scheduled for September 28, 2022. Based on the convictions on 8 counts of sex trafficking in violation of the Mann Act, 18 U.S.C. Section 2421, the defendant is subject to mandatory restitution, which shall be issued and enforced in accordance with Section 3664 in the same manner as an order under Section 3663A. See 18 U.S.C. Section 2259B3. To date, defendant has not paid any portion of the fines imposed by the court and still owes the entire $140,900. They can leave that $900. The government has been informed by the BOP that the defendant had accumulated substantial funds in his inmate trust account. As of August 3rd, 2022, the defendant had $28,328.24 in his inmate trust account. God damn, R. Kelly, you was living large, God damn it. I know that's right. The king of R&B is living large. All that goddamn money? Shit. What the fuck? By letter dated August 3rd, 2022, the government requested that the BOP restrain the funds in the defendant's trust account. The BOP confirmed that the requested amount was restrained on August 4th, 2022, today. Further, the BOP has confirmed it that it left $500 in the defendant's trust account for the defendant use in the MCC Chicago. They left the man $500. Accordingly, as of this writing, the BOP has restrained a total of $27,828.24. The government now seeks entry of an order authorizing the BOP to turn over the restrained funds for application to the defendant's outstanding criminal penalties. Y'all got to find some other way. Statutory and legal framework. Section 3613, Title 18 of the USC sets forth the procedures for the government to enforce criminal monetary penalties. Under this framework, a judgment imposing a fine may be enforced against all property or rights to property of the person fined. 18 U.S.C. Section 3613A. The only property exempt from the subsection is that which the government could not reach for the payment of federal income taxes. Case law also provides, let me see, the federal taxes. Okay. Section 3613C also provides that the judgment creates a lien in favor of the United States on all property and rights to property of the person fined upon the imposition of a fine, assessment, or order of restitution. A person sentenced to pay a fine or other monetary penalty, including restitution, shall make such payment immediately, unless in the interest of justice, the court provides for payment on a date certain or in installments. 18 U.S.C. Section 3572D1. Section 3613C provides that money received from a defendant shall be disbursed, in the following order of priority. 1. A penalty assessment under Section 3013. 2. Restitution to all victims. 3. All other fines, penalties, costs, and other payments imposed. The JVTA assessment is not payable until special assessment, restitution, and fines have been satisfied. Reference. The Mandatory Victims Restitution Act, 18 U.S.C. Section 3663A, provides that when a person obligated to provide restitution or pay a fine receives substantial resources from any source during a period of incarceration, that person shall be required to apply the value of such resources to any restitution or fine still owed. 18 U.S.C. Section 3664. Courts have acknowledged that the language of Section 3664N requires the turnover of substantial resources received by inmates during their incarceration if those inmates have outstanding criminal monetary penalties. Reference. The 10th Circuit of 2019 held that any person obligated to pay restitution may be ordered to make additional payments if he receives substantial resources from any source, citing 18 U.S.C. Section 3664N. In addition, numerous courts have specifically permitted the turnover of funds that accumulate in an inmate's trust account to satisfy criminal judgments. Case law. The Ninth Circuit in 2018 held because Hester's inmate trust account showed that he received substantial resources during his period of incarceration, he was required by law to apply those funds to the $329,767 in restitution he still owed. Case law. The 10th Circuit in 2018, under 18 U.S.C. Section 3664N, defendant had an obligation to commit substantial funds in his inmate trust account to unpaid restitution. District Court did not err in issuing a turnover order. Case law. The Seventh Circuit in 2017 held that inmates' participation in Inmate Financial Responsibility Program, IFRP, does not preclude the government from seeking turnover of funds in inmate trust account to apply against restitution. If an inmate has a substantial sum in inmate trust account, inmate is required under 18 U.S.C. Section 3664N to apply it to restitution. Case law. The government has the responsibility to collect unpaid fines and restitution owed to crime victims. See 18 U.S.C. Section 3612C. Moreover, the Crime Victims Act, 18 U.S.C. Section 3771, provides, among other things, that the victim has the right to full and timely restitution. To achieve those ends, the government may enforce a judgment in accordance with the practices and procedures for the enforcement of a civil judgment under federal law or state law. See 18 U.S.C. Section 3613A, and may use the method set forth in subchapter C of Chapter 22.7, Sections 3571 through 3574, and subchapter B of Chapter 229 of Title 18, Sections 3661-3614. Now, this doesn't mean that he was sued by anybody, right? They're saying that based on what they're referencing here, that they are allowed to support the accusers of victims, or whatever you want to call them, alleged victims, with money that they recoup, right? As if they had a civil lawsuit. They're not saying that somebody sued them. They're not necessarily saying somebody sued them, but they're saying that based on that particular procedure or reference that I read off, they are able to do that. So don't go trying to kill the people. Let me see, what was See also 18 U.S.C. Section 3664M. In connection with the enforcement of restitution, the government is also entitled to use all other available and reasonable means. See USC Section 3664M1A2. These statutes, coupled with the lien created on behalf of the United States pursuant to Section 3613C, empower the government and the court to protect against the disbursement of funds that could be applied to restitution. See, okay, that's case law. Where am I? Okay. All Writs Act prohibiting the defendant from receiving the funds of a civil settlement before a restitution judgment had been entered. So I guess that's what happened in that particular case. Number 3, basis for the proposed order. The defendant has amassed nearly $30,000 in his inmate trust account over the course of the last 3 years of incarceration. The defendant has not made any payment towards the substantial criminal monetary penalties imposed upon him at sentencing, even though payment was due immediately. According to Section 18 U.S.C. Section 3572D1, a person sentenced to pay a fine or other monetary penalty shall make such payment immediately. In addition, the amount of money in the defendant's trust account significantly exceeds the amounts courts have accepted as meeting the substantiality requirement of Section 3664N. Reference. The Fifth Circuit in 2019 held that accepting argument that approximately $1,684.57 in inmate trust account was a substantial resource requiring turnover. reference. It says, I really don't have to read all that because it's just talking about the amounts and stuff that was that the court deemed that they should turn over in these particular cases. Let me skip down to here. It says, furthermore, the government's lien against the defendant's property extends to the funds in the trust account because those funds are not exempt from seizure by the plain text of 18 USC section 3613A. Nor does it matter that the defendant did not accumulate these funds in one uh, fell swoop. So guess what? Sylvia should come back and cuss y'all out. Cause see, they was sending some money to some kind of cash out, right? Now they done got the funds out of this shit here, out the inmate account. See, that what you I'm trying to tell. I don't know why y'all listen to the dummies. And I did say too, I say, send it to the people. But I did warn you that they can put an order out to garnish those funds. But hey, she had so much motherfucking shit coming against her. Now look what happened. All y'all hard money. I ain't taking up somebody. I'm reading what it is. And hey, y'all had an alternate way of sending money and shit. That's going to somebody that know R. Kelly. And here we go. Now I'm reading this shit on August the 4th, 2022. Got y'all funds. Let me keep going. Okay. Nor does it matter that the defendant did not accumulate these funds in one fell swoop. Case law. The 11th Circuit in 2020 rejecting the defendant's argument that Section 3663N does not apply to a gradual accumulation of money from family, friends, and prison wages. Reference. The MVRA requires prisoners to apply substantial resources from any source, not just from windfalls, to their restitution obligation. Accordingly, the defendant must be required to apply the value of the resources in his inmate trust account to his criminal monetary penalties. Reference. Importantly, in consideration of the rights of the victims of the offense of conviction to full and timely restitution, as provided in 18 U.S.C. Section 3771, and to ensure that the monies are dispersed in accordance with the requirements of 18 U.S.C. Section 3572D, the money should be deposited in an interest-bearing account pending the determination of restitution. As provided in the proposed order, the monies would be paid first to the special assessment of $900, next to any restitution imposed, with the remaining amount to be paid to the outstanding fine. Based on the foregoing, the government respectfully requests that the court grant its motion and order that the BOP turn over the funds in the defendant's trust account to the clerk of court for deposit into an interest-bearing amount pending the sentencing hearing on restitution, currently scheduled for September 28, 2022. A proposed order is attached for your honor's consideration. All right, let me read the footnotes real quick. That footnote says the defendant is currently incarcerated at the MCC Chicago, pending trial in the Northern District of Illinois on separate charges. Number 2, Section 8.8 of the BOP Inmate Trust Fund Deposit Fund Manual grants wardens the authority to encumber funds in those amounts upon the request of any attorney or agent of the government where debt is owed by the inmate. Reference. Section 10.1 of that same manual authorizes withdrawal of funds without consent of the inmate to comply with any federal court order. Now, why do people, all these people that work at the BOP and all these different places, why y'all ain't telling these people about this shit here? The fuck? Number 3, Section 3613A is made applicable to restitution by subsection 3613F, which provides that all provisions of this section are available to the United States for the enforcement of an order of restitution. And I thought so. No. Number 4, for criminal debts such as fines and restitution. Federal law provides that the only categories of exempt property are one, wearing apparel and school books, two, fuel provisions, furniture and personal effects, three, books and tools of trade, business and or profession, four, unemployment benefits, five, undelivered mail, six, annuity or pension payments under certain specified federal statutes, seven, workmen's compensation, eight, judgments for support of minor children, nine, certain service connected disability payments, and 10, assistance under the Job Training Partnership Act. See Section 18 U.S.C. Section 3613A1. Number five, the JTVA assessment would be paid out of any remaining funds after the fine is paid. See 18 U.S.C. Section 3014. Okay, and um this is the order, I guess, that they proposed. So let me come on right now. Lord, Team Kels, don't pass out on it. Let me come on right now. I hope y'all ain't dead in the chat. Lord, I hope y'all still breathing in the chat. Y'all still breathing in the chat. I'm back right here. Don't pass out in the chat, please. Thank you, Dolores, for trying to get those likes. Thank you so much. I appreciate you being in here, part. Hey, Star. Hey, Little Red. Let's say hey to some more folks. No, I think I got nobody. Hey, Whitney Miller. Hey, Sonya Davis. Yes, Nikki Wright. You back. I like old Nikki Wright. Let me see. So let me put up. Child, listen here. She don't kill me. So I'm going to also read, I guess, what happened on the call yesterday. Then I'm going to get to that motion because, of course, we got to break that down. I appreciate y'all hanging on in there with me. I'm a little fresher today. I guess my goddamn ankle. Okay. I don't know why we can't be normal. Why we can't behave normal. Like, you know, if your ass is normal offline, you should be able to be normal online. I don't know what the fuck is wrong with these people. Well, we'll see. What is this? Okay, that's that. Okay. All right. So, yeah, this is what happened on the call yesterday. It says minute entry before the Honorable Harry D. Lynn-Weber video pretrial conference held. For the reasons stated on the record, the government's motion to impanel a confidential jury 246 is granted. So they granted the confidential jury. The court's rulings on the motions in limine 211, 221, 224, 227, 231 can be found in the attached order. This is which I'm going to read. The government's oral motion to conduct a remote examination of a witness is granted without objection. Okay. The government shall file its response to defendant's Brown motion to compel discovery 247 on or before Friday. So I'm pretty sure that's the motion to compel with regards to well, that's Brown. There was we gotta go back and see what that is on 247. And it said Brown may file a reply on or before Monday, August 8th. The government shall file its responses to Kelly motions to introduce evidence under Rule 412, and that's docket 237 and Pacer. Kelly's motion to compel discovery, docket 242 in Pacer, and Kelly's motion to bar testimony from the government sexual abuse expert 243 on or before Monday, August 8th, 2022. So, listen, and it is normal to mail a notice. So, listen. So, remember, I told you with this particular judge, he handles things in one swoop, like a one-stop shop. Okay, which he's getting on my goddamn nerve with this. Okay, but we're gonna, you know, trot through this shit. So we got to go back and see exactly what all he's talking about. So let me take this down and let me put up this long-awaited motion in limine. His rulings, right? Y'all good? Everybody good? Everybody made it. Everybody all right? Oh, thank you, Star. I appreciate y'all too. I love y'all. Y'all so goddamn whew, common presence. Trying to tell you. I don't like, I don't like all kind of bullshit, whining and crying. Oh, he hit me back. Oh, he said, oh shit. I don't like all that. All right, so the longer awaited ruling on the motions in limine. So I don't know if he addressed it all or he could have put in a reserved judgment. I'm not sure. So we'll read it though. He should tell us. Okay. Ooh, child is so generic looking. Okay, rulings on motion in limine. Lord help Judge Lennon Webber, Jesus. Okay, USA motion number 1. Motion to protect the identities of certain victim witnesses. The government requests that the victim witnesses and minor one's mother be permitted to use pseudonyms during testimony. The government requests that any references to the victim witnesses or minor one's mother in open court by the pseudonym or first name only. The government requests that no one disclose the addresses, full names of family members, of the exact place of employment of any of the victim witnesses, minor one's mothers, or individuals D. Defense response. Kelly does not object to the motion, ruling the motion is granted. Okay, we straightforward to it. USA motion number 2. Motion to preclude evidence of victim's sexual history. The government requests that any inquiry or evidence related to the victim's sexual history be excluded. Defense response. Kelly states that he has no intention of introducing any evidence for the purpose of sexual predisposition, but states that victims' previous sexual behavior may be relevant to questions surrounding consensual sex acts with Kelly when the victims were not minors. Kelly objects to the exclusion of evidence regarding sexual conduct of witnesses who were not victims identified in the indictment, ruling the motion is granted. So that means that the government won that. So there would be no evidence of the victim's sexual history. So now I got to go back and put it together because this is how he gets down. Okay, the judge. Lord have mercy. Number 3, U.S. motion number 3. It says motion to bar evidence and argument related to consent. It says the government requests that the court prohibit defendants from introducing evidence and arguing that the minor victims consented to engaging in sexual activity while minors. The government argues that minors lack the capacity to consent. True. Defendant's response. Kelly does not intend to argue that minors are able to consent. However, Kelly argues that he should be allowed to cross-examine the minors about their conduct to negate inducement, ruling. The motion is granted. Kelly may not argue that the minors consented to any sexual behavior with him. So I ain't have to redetermine that. Now, remember I said when it comes to motion in limine, do anybody remember what I said they do? I'm not on the screen. What that process is pretty much doing is shutting down defenses, right? Shutting down defenses or shutting down the prosecution pieces of their case, right? Because both sides submit motion in limine, right? And that's what they that's pretty much the crux of it, right? They're trying to shut down either defenses or introduction to to pieces of the case, right? So the government won that one as well. So now let me see. So they said Kelly does not intend to argue that minors are able to consent. However, Kelly argues that he should be allowed to cross-examine the minors about their conduct to negate inducement. So what that means is, I guess there was going to be a kind of, the situation with the text messages, right? Remember, J-Bo was going to use those text messages to show that it wasn't R. Kelly that did the inducing, coercing, enticement, and all of that, right? I guess she was going to try the same thing here And the judge says, no, you can't use a piece of evidence to show that it was the girls, because apparently all of them were minors at the time of alleged minors at the time of the alleged incident that happened. So now J-Bo, he's saying that J-Bo cannot use evidence to show that it was the victim witnesses that indeed did the enticing, inducing, coercion, and all of that, right? So that's another defense gone. So the government won that. It says USA motion number 4, motion to prevent the public display of child pornography videos during trial. The government wants the court to prevent the publication of child pornography to the gallery overflow courtroom during the trial. Defense response, Kelly joins the motion. Means that they agree with the government. So, and the motion was granted. That's straightforward. USA motion number 5, motion to introduce evidence or polygraph examination. This would be interesting. The government seeks to introduce evidence and testimony about polygraph examinations for reasons unrelated to the correctness of the results. Okay, let me say that again. The government seeks to introduce evidence and testimony about polygraph examinations for reasons unrelated to the correctness of the results. Okay, so the government isn't trying to use the polygraph to talk about the results. I guess they may be trying to use the polygraph to say, yeah, one was done, and this is as part of the whole story with regards to the conspiracy, right? And it says the government argues that this evidence is probative, meaning it proves something, probative evidence of the conspiracy charge in the indictment. So if I would have kept reading, I would have answered myself. So you know how I do that sometimes. So that's what they were using. Defense response. Kelly does not object to the fact that the polygraphs were used by McDavid. Kelly objects to the testimony about the questions and argues that the results of the polygraphs are as unreliable and unduly prejudicial. So the government won that because it says the motion was granted. So they will be using those the polygraphs to show that there was that was a big part of the conspiracy, right? So that's what they're showing. So the government won that. USA motion number 6, notice regarding introduction of the false records alleged in the superseding indictment. The government intends to admit a memo summarizing an interview of individual D to show that McDavid and Kelly conspired to obstruct justice. The government alleges that the memorandum contained false information and is not privileged. Okay, the government alleges that the memorandum contained false information. So it must be when they allegedly went down there and said they gave false information to the cops. Well, let's see. Let me read. Defendant's response. Kelly objects, stating that the memorandum is not relevant evidence. Kelly also objects to the introduction of any police report. So yeah, that's what it is. That allegedly contains false statements of minor 1. The ruling is granted. So they're using that also as a part of the conspiracy, right? So the government won that. I'm gonna start waiting and just read the whole thing because maybe I don't have to exert no brain power. USA motion number 7, government's notice of intent to admit direct evidence of crimes charged. The government intends to introduce testimony and evidence of the physical, emotional, and sexual abuse that Kelly inflicted on minors 1, 3, 4, 5, and 6. Defendant's response. Kelly objects to the introduction of any evidence that is not directly relevant to the crime charge and any evidence that is barred by Rule 403. Let's see what it says. Ruling. Grant the motion. Defendant may raise objections during the trial if they see fit. So, what he's saying that they're going to grant it, but if any time the defense feels like they, the government is introducing evidence with regards to, let's see, the evidence with regards to the physical, emotional, and sexual abuse, they can object, right? And they may cite during the trial that is barred by Rule 403, right? Which is a rule of evidence. Okay. So they're probably going to object and they're going to state why they think that that particular evidence should be barred, right? And right now they're saying they can object for other reasons, but right now we see that it's largely going to be about Rule 403. All right, so the government won that. It says USA motion number 8, motion for prior notice concerning Rule 608B, impeachment. Now 608, that's also a rule of evidence, right? But this has something to do with impeachment, impeaching somebody's testimony or something else. Let's see. It says the government asks that the court bar all parties from introducing evidence under Rule 608B, except upon prior notice outside the presence of the jury. Okay. The government proposes that parties first notify the court and other parties at sidebar of its intent to impeach under the rule. Okay, let me see. Notify the parties at sidebar. So maybe they might have some type of statements or something that would, the defense may have some type of statements or something that, or some, something in that matter that may impeach what someone that may get up on the stand and say. Maybe they have something that they say, maybe the defense has something that somebody said during social media that will contradict what they say on the stand. Let's see. So defense response. Brown argues that the government's request is unprecedented. Brown notes that Rule 608 does not contain a notice for provision. Okay. Kelly also objects to the motion. The motion is denied. So the defense won that. They got one. Okay. So, but what they won, okay, let me tell you what they won. They won that the government asked the court bar all parties. So they look like they can introduce evidence without prior notice. That's the evidence that's under Rule 608B that has something to do with impeachment. And they don't have to first notify the court at a sidebar to do so. So they can introduce this evidence just like during like a normal proceeding, and they don't have to give a prior notice to do so or have a sidebar in order to introduce this evidence during the court. That doesn't mean that the evidence will be admissible, but if it is, they don't have to do all of this notification and have a sidebar to introduce it. So okay, so the defense won one. Okay. And hold on, this was from our girl Mary Judge, right? This is from Mary Judge, and this is where J-Bo, I believe she adopted this particular part of Mary Judge's motion. This is from the federal defender. So shout out to Mary Judge. Yeah, I think she's a black sister. Not that I care, but I'm just saying. USA motion number 9, motion to preclude argument or evidence designed to elicit jury nullification. This motion is broken down into several subparts as seen below. Okay, and jury nullification is just like the jury just automatically think, hey, he's guilty, and that's what we're gonna do. We're gonna, adjudicate him guilty before, we're gonna sit him during this trial, but we already got our mind made up. Pretty much what it means. All right. It says USA Motion 9A. Motion to preclude argument or evidence concerning potential penalties faced by defendants if they are convicted. The government asks that the court preclude defendants from introducing evidence or argument discussing the potential possibility, the possible penalties or sentence should the defendant be convicted. Defendant's response: no objection. The ruling, the motion is granted. USA Motion 9B. Motion to preclude allegations of outrageous government conduct. The government moves to exclude evidence or argument by counsel of outrageous government conduct, which is again shutting down a defense, right? Just in case she says, the government pressured somebody to take the stand, or the government withheld withheld certain evidence, whatever. If they didn't or whatever, that's pretty much, what they're trying to say. Outrageous government conduct. The defense, no objection. So that ruling is granted. Motion 9C. Motion to preclude argument and evidence regarding the government's motivation in investigating and prosecuting the case. Okay, as you see here, this is shutting down a defense that the prosecution has any type of unethical type of behavior, right, with regards to prosecuting this case. Let's see what it says. It says the government moves to exclude any evidence or argument relating to any officers or agents' motivation for investigating or prosecuting the case. The defense, no rejection. The ruling, the motion is granted. And the reason why I believe that the government put that in that motion of limine, because they've gotten a sense of how J-Bo gets down. They know she goes after prosecutors, the rights of the defendant, evidentiary rulings, how the judge may be biased or not. So I believe they just trying to jump ahead and box J-Bo in, just in case she comes with that. USA Motion number 9. Now, also what that means is, let's see. One, so we know they can't, the defense can't make objections with regards to that. That may play a part if he is convicted. That may play a part going forward on the post-conviction motions, right? Because here they already took this up, right? Now, J-Bo could say, but then here, this is going to be a problem. If she has, if during the post-conviction phase, right, which is post-conviction motions and appeal and going forward, right, after the trial is over, if he is convicted, J-Bo can raise an issue and talk about the talk about the prosecution's motivations if it is discovered, right? She can do that. But, pay attention to what I'm saying. But under what they are already addressing now and the objections to it, and the judge has already granted, if you can't just say without evidence or anything like that, the prosecution had some type of misconduct with regards to certain things, right? Like this motivation to prosecute the case and outrageous conduct, and what's the other one? Potential penalties faced by defendants if they're convicted, shit like that. So that's what they're trying to. This is not to say that she cannot raise issues with the prosecution going forth on if he is convicted, but it has to be like something newly founded during the case. Okay, and it has to be evidence of, like, she has to have some type of evidence. It cannot be just an allegation. Okay, you understand what I'm saying? Cannot be just an allegation. Got to have evidence of. All right. Let's see. USA motion number 9D. Motion to preclude argument and evidence of selective prosecution theory. All right. Remember, so I can tell you right now, that means, like, okay, so they know how she get down with the civil rights and all of that. So she, if just in case she has an argument, well, judge and jury, your aunt, judge and jury, it seems like they are prosecuting blacks more often and more harsher for charges such as these than those of whites in any other race. All right, let's read it. It says the government moves to exclude any evidence or argument that some witnesses who participated in the conspiracy to receive child pornography were never charged. Okay. The government also moves to exclude any evidence or argument that the parents of the victim witnesses should have known about the minor sexual relationship that Kelly, and by saying nothing, consented to the relationship. Again, shutting down her defense, right? Shutting down her defense. So, and that also falls upon the selective prosecution. So what I said, as well as in any of this, okay? So, and this comes from what? YouTube and all of that. This is directly verbiage from YouTube, right? Let's see. Let's keep going. The defendant's response. Brown argues that the government's request is impermissibly broad and that the evidence and arguments regarding the parents of minor one are irrelevant. Okay? Brown argues that Kelly's relationship with minor one's parents is relevant to Brown's belief that minor one was of age or that Kelly's relationship with minor one was not sexual. Okay, so this could be one of the possible defenses that because the parents allegedly knew that was a sexual relationship was going on, that would have led R. Kelly to believe that minor one was of age of consent in that state, right? That could be a possible defense. Not saying it is, but they're trying to shut down any type of talk like that, any type of selective prosecution, meaning they select, because remember I always tell you the prosecutors select who they're going to prosecute. I know a lot of people want all the parents locked up, but that's an arduous process, and it, one, you have to say that the parents knew what was going on, and two, consented to it, and all that type of shit that falls, and you got to have proof of all of that. Okay, you just can't think it and believe it. Got to have proof of all of that. And even if you did have proof of all of that, still up to the prosecution to decide whether or not that they are going to prosecute those parents or anybody else that may be involved in this situation, right? That maybe should face charges. The government is trying to shut down that particular defense, right? Because listen to this. When you put that out there to a jury, and some in the paragraphs before, like the prosecution, they are motivated to go after Kelly for this and motivated for that or whatever. They're doing them so wrong, whatever. If you're allowed to put that out there to a jury of 12, remember they are human beings that's sitting on that stand, right? That could make them focus more on the message and less on the evidence. And when you got the judge is going to instruct them in the jury charge, which is the jury instructions, that you're supposed to make a determination based on the evidence presented before you during the trial, right? So they're trying to shut down any of that because that can, what they say, confuse the jury, right? And that is a legal and a viable argument that one can make in a motion that something can confuse the jury. All right. I hope I explained that. So let's see in the ruling. The motion is denied in part. Oh shit. Brown may argue that he believed any victims were not minors. Uh-oh. The motion is granted as to exclusion of evidence that minors or their parents consented to a sexual relationship with the parent. Hold on. Motion is denied in part. Okay. May argue that the motion is granted as to the so the parents part. Parents that the parents knew and all that bullshit, that won't be allowed. But he can argue that that he believed any of the he argued that he believed any of the victims were not mine. That he believed that the victims were of age. So he can argue that. Now remember, this is our girl, Mary Judge, that's getting some of her shit approved. Let me see what she getting approved so far. She got that. Let me see what else Mary Judge got. God damn it. Let me see. She got number 8. Motion for prior notice concerning Rule 608 impeachment. So Mary Judge got 2 up in there. Go on, Mary. We say y'all put Mary in the chat. I can't see y'all, but y'all gonna put Mary in the chat. I'm proud for Mary. Go on, Mary. Girl, shit. What's your cash app, girl? Let's see. USA motion number 10. Motion to exclude discovery request or commentary regarding discovery in the presence of the jury. The government asks the court that the court preclude the parties from requesting discovery or otherwise commenting on discovery matters in the presence of the jury. Defendant's response. Kelly does not intend to have discovery disputes in front of any jury. That's common sense. Yeah, the motion is denied as mute. So that's common sense. Duh. Okay. USA motion number 11. Motion to exclude evidence of arguments regarding the constitutionality of the statutes criminalizing the production and receipt of child pornography. The government alleges that arguments which pertain to the constitutionality of statutes criminalizing child pornography offenses are wholly irrelevant to the indictment in this case. Defense response, Kelly has no objection. The motion is granted. Let's see, motion is right. Okay, so that's common sense. The child pornography is illegal. That's common sense. Okay, USA motion number 12. Motion to preclude argument or evidence of non-pertinent traits of defendant's character. Right. So you have to. This is like, you are trying to introduce somebody's character or whatever. You have to. It has to be, like a trait of someone. Well, let's read. The government moves to exclude defendants from presenting evidence of their lawfulness except by reputation or opinion evidence. All right. Defense response. Brown argues that he may present testimony of his character of being a law abiding citizen through specific instances of conduct. Kelly intends to abide by the rules of evidence and does not intend to affirmatively introduce evidence of good character. Ruling. The motion is granted. Defendants may introduce evidence of being law abiding, but only through reputation or opinion testimony, not through specific instances of conduct in line with Rule 405. So remember, I told you that you have to, when you're talking about your character, whether it's through a character witness or what, it has to be a trait. That's something that's embedded in you consistently throughout. It can't be, okay, in 1996, R. Kelly gave some money to a cancer survivor. Okay, now those type of things you could take up. Just say if he gets convicted, whatever. Of course, you could take that up as in the witness. I mean, in the um, when in statements, right? Like you can, when they get up to support R. Kelly, whatever, when they read their letters and things in support of him, you could talk about the stories and all of that, like was introduced by J-Bo and what in the letters that she selected to turn in her sentencing materials, right? You could do that, but during the trial, it's only going to be limited to a consistent trait. Your trait, what's embedded in you, what's natural. This is how you act. This is your character, your sustained character, right? This is how you do. Okay. So, um, so the government won that one. Okay. USA motion number 13. Motion to preclude defenses of alibi or unavailability of mental defect. The government moves to exclude any evidence or argument relating to alibi or mental defect because defendants did not provide the adequate notice prior to trial. Hmm. The government moves to exclude any evidence or argument relating to alibi or mental defect because defendants did not provide the adequate notice prior to trial. Let's see. Defendant's response. Kelly argues that he cannot provide an alibi at this time due to the indictment's allegations that the offenses spanned 20 plus years. Mhm. So I don't know if they're saying that maybe he has no record until recent, with the when he spoke with the mental health professionals, whatever, no record of ever going to see anybody in the time allotted. You know what I'm saying? Like over the years, like he had some type of mental health issues or disability or whatever. Therefore, they're saying it shouldn't be introduced in a trial prior to this trial. Let's see what it says. I'm just guessing at this. It says the motion is granted according to rules 12.1 and 12.2 of the Federal Rules of Criminal Procedure. The defendant must provide advance written notice of any potential alibi or insanity defense. Okay, so they're talking about the defense. Okay, okay. So now listen. When you're talking about insanity during the trial, when you're talking about insanity during the trial, these are the exculpatory defenses that I we used to talk about right last year. Justification and excuse. This does not completely exonerate you of the crime, right? Per se, it just decreases your criminal liability with regards to it, right? Now, but that doesn't mean that you can that you won't that but it does mean that you can be found not guilty. Okay, let me explain this, right? Because it's different than having an insanity plea. That's not what this is talking about. Insanity plea, that's something totally different. I'm talking about a justification or excuse defense, which are all exculpatory defenses, which minimizes someone's criminal liability. It doesn't absorb them of any crimes or anything like that. It just minimizes. Okay. And if the your lawyer is pretty good, a jury can see that and say, okay, well, he had all this going on, right? So we're going to find him not guilty. That's different than an insanity plea. Okay. That's different than an insanity plea. Okay. And that's also different than somebody finding you insane during the trial. Two different things. Insanity plea is just what it is. I'm not guilty because I'm insane. And that requires a level of determination by some type of professional, right? You're so insane that you definitely didn't know that you was committing crimes. That's something totally different. Insanity plea. All right. So they're just saying here that the defendant must provide in advance written notice of a potential alibi or uh, or insanity defense, right? So potential alibi, meaning just what I said, insanity plea, or insanity defense is what I say is an exculpatory defense, which means they justifying it or excusing it, which doesn't mean that you're not guilty. You're just saying this happened because I'm a little off. Okay? Two different things. So the government won this. So they are saying that the defense must, if they plan to use either one, they must tell them, give them written notice, provide, written notice in advance prior to trial. Okay, let's go. It says USA motion number 14. Motion to preclude defense counsel from defining the term reasonable doubt. It says the government argues that it is improper for attorneys to define the term reasonable doubt. Defense response none. Ruling is great. I think this is the part where J-Bo kind of got like a little smart. Somebody did. And was like, okay, she said, I do know how to, you know, present my case in chief without having to break down, reasonable doubt and all of that. I know how to lay out my case where we're not defining and spending extra time and emphasizing what reasonable doubt means. Okay. Because sometimes, if that is allowed, sometimes you can present it in such a way where saying, like if you have a lawyer that says if you just got a question, a doubt in your mind, and that's reasonable doubt. And that's not really how that's not what it means according to the law. So, but if you tell a jury that, and they were like, if they saying, well, he sound guilty, well, I'm not sure, you know. So that to me, that's reasonable, and that's reasonable doubt. I reasonably think he might be guilty, but I ain't sure. So since I'm not sure, he's gonna be not guilty. Okay, that's what they're trying to prevent. All right, it says USA motion number 15, motion to allow government to recall the case agent during its case in chief. A case in chief is just whatever side is presenting their case. Okay, you start off with the prosecution case in chief. Okay, they're laying out their case, and then when it's the defense turn, it's their case in chief. Okay, it says the government asks permission to recall the case agent during trial. The government proposes that after every direct examination of the case agent, the defendants can cross examine the case agent. Defendant's response: Kelly argues that the court should use its discretion and not allow the government to recall the case agent too many times. Ruling: the motion is granted. However, the court may use discretion to prevent the government from needlessly recalling the case agent, which makes sense. Okay, you don't want to be all day keep calling the case agent, all after to go back and forth to straighten something out after a cross examination. All right, USA motion number 16, motion to admit business records pursuant to federal rules of evidence 8036 and 90211. Okay, let's see what this says. The government asks that the court admit the evidence listed in Government Exhibit 1 under the business record exception. Okay. Defendant's response: Kelly does not object, but asks for reciprocity, if he seeks to introduce similar evidence. The motion is granted. The Santiago Prophet. Oh my gosh. Oh, wait a minute. Something else came in. Hold on, y'all. Hold on. Hold on. Oh, okay. That's repeat. All right. Sorry. Wait a minute. Okay. Okay. So they're going to exchange evidence on that. So they're going to exchange evidence up there if it's duplicate. And then the USA Santiago Prophet. Here we go. Let's see how much. Okay, 7 to 12. All right, I'm on page 7. USA Santiago Prophet. The government asks that the court admit specific categories of statements made by co-conspirators in furtherance of the alleged conspiracy into evidence pursuant to Rule 801 D2E. The motion provides an overview of the evidence that the government expects to introduce, demonstrating the existence of a conspiracy. Okay. Defendant's response. Defendants Brown and Kelly. Is that something else? Hold on. Okay. Defendant Brown and Kelly allege that the Santiago proffer is insufficient because it does not identify which exact statement it wishes to introduce into evidence. Brown alleges that the lack of specificity forecloses him from drafting necessary limiting instructions. Remember, I told you limiting instructions is the instructions that the judge gives that a particular piece of evidence or something be used for a specific purpose, and that's it. Something being used for a specific reason. That's what it means. Okay. Ruling. The motion is granted. If the defendants believe that the government has not actually proved the existence of a conspiracy during the trial, they may make a motion to strike or raise an appropriate objection. So remember, I told you when it comes to co-conspirators, it's a bunch of shit going on, right? A lot of hearsay type shit, dealing with confrontation clause, and then you got Crawford, and you got Bruton, and all of that. You have Virgilia, you have all of that, right? So, which is all being um, raised during, argued and objected to during the paperwork, right, process. Okay, so you have these statements, right? That's what deals with the Santiago problem. So remember, I told you that when it comes to co-conspirator hearsay, you got to also have some type of evidence along with those statements to prove that there it was actual conspiracy. So what the judge is saying that if the prosecution goes on and all they have are these statements and stuff, they don't have actual other evidence to support that there was an actual conspiracy, that they may make a motion to strike and raise appropriate objections as it goes, saying, hey, Your Honor, you know, they haven't substantiated there was an actual conspiracy that went on by another piece of evidence. And the statements is also evidence. Okay. Brown motion number 1. Let's see how a girl married judge do, y'all. Let's see. Okay. Motion to permit Mr. Brown to admit evidence of his own character. Defendant Brown argues that he should be allowed to present evidence that he is a law abiding person. Government response. The government admits that Brown may offer evidence of must supposed to be his reputation for being a law-abiding citizen, providing it come in the form of opinion testimony. That's self-explanatory. The ruling. The motion is granted in part. Mary got 3. Defendant Brown may only introduce testimony of his character in the form of reputation or opinion evidence. Should he do so, the government may refute the testimony on cross-examination using specific instances of conduct. Meaning, if they have some specific somebody giving his opinion of Brown in some kind of way that he's a law-abiding citizen because of this, that, and whatever. He has a reputation of being a law-abiding citizen, whatever. If the government has something that says otherwise, they can use it. Okay, y'all keep total. Ms. Brown got 3. Mary Judge got 3 in there. Brown motion number 2. Motion to preclude the government from eliciting testimony regarding certain other crimes, wrong, and acts by Mr. Brown. This motion is broken down into several subparts as seen below. Brown motion number 2A. Motion to exclude testimony regarding Mr. Brown making travel arrangements for minor 4 and 6. Oh yeah, also, so where Mayor Judge, well, let me use the defense, where Brown won 3 motions, is won 3 of these already, right? If those are the areas where J-Bo adopted, she also wins, right? Okay, so just keep that in mind. If it pertains to R. Kelly, you know what I'm saying? So if it pertains to the defendants as a whole, she also wins for R. Kelly. Now, if Jeremy David didn't jump on this don't pertain to him. Okay? Those areas where she won don't pertain to him. Okay? So let me start over a little bit. It says motion to exclude testimony regarding Mr. Brown making travel arrangements for minor 4 and 6. Brown specifically seeks exclusion of grand jury testimony for minor 4 and 6, detailing how Brown booked their hotel rooms as they were minors. Government response. The government argues that Brown's travel arrangements constitutes direct evidence of the offenses, right? Remember, Mary Judge is trying to use that defense that, okay, well, Brown didn't know that they were minors. Brown didn't know nothing about who was on the tapes, that they were minors or whatever. Brown don't know shit, okay? But I believe the government is trying to use this evidence to say, yes, you do. So let's see what it says. Okay. Ruling. The motion is denied in part. Was that Mary Brown got 4? Wait a minute. Go ahead on Mary Brown. I think she got 4. Okay, ruling. The motion is denied in part. The government may discuss Brown's travel arrangements as direct evidence that Kelly enticed minors into sexual activity. However, the government may not argue that because Brown made travel arrangements for specific minors, it was more likely that he knew different minors were depicted in certain videos. Boom! Hit that and then hadn't even got there. Go on, Andrew. Oh, pop your collar. Pop your collar. Hey, Walker, pop your collar, girl, pop it. Yeah, so that's self-explanatory. Well, it's not self-explanatory, but as I stated, so let's see. However, the government may not argue that because Brown made travel arrangements for specific minors, it was more likely that he knew different minors were depicted in certain videos. That's huge for him. That's huge for Brown. That's huge. Okay? Now it looks a little better. Now her defense, Mary Judge's defense, just got a lot tighter. How are you going to prove that Brown participated in a conspiracy if he didn't? And a conspiracy normally means that somebody's doing something wrong. So you got a 2-part here. Now, this is just me. Okay? 1, he didn't know he was doing something wrong. Because 2, he did not know that the people in the videos and the people he booking rooms for were minors. So you got a 2-4. Yeah. Go ahead. Is that 4 for Mary? Come on, Mary. Come on, girl. What's your cash app? We're going to buy you some coffee or something, a little Danish or some shit. Girl, you're knocking this out, girl. I told you that shit was good, she wrote. Let's see. Brown motion number 2B. Motion to exclude testimony from individuals B and D regarding Brown's role in arranging abortions for Kelly's partners. Brown specifically seeks exclusion of testimony from individual D, stating that Brown took her to an abortion appointment and posed as her uncle, and testimony from individual B that Brown arranged abortions for minors on Kelly's behalf. Government response. The government states that it does not intend to introduce any evidence on this topic in its case in chief, ruling the motion is denied as mute. So she won there too. That five, she won there too. Because the government didn't put up any resistance. They said they're not going to introduce any evidence on that topic. So the Brown took a get abortion and pulled it up. Okay, and testimony from individual B that Brown arranged abortions for minors. So that's pretty good. And they didn't, because most likely the government does not have evidence. Um, individual B that Brown arranged the evidence that would actually prove that Brown was out there arranging appointments and taking people to the doctor for underage girls who got pregnant from R. Kelly. So, is that five? Y'all keep up, keep track. Go ahead on, girl. Let's see. Brown's motion number 2C. Motion to exclude testimony from individual B regarding Brown's role in inviting Kelly concert attendees backstage. Brown specifically seeks exclusion of testimony from individual B, suggesting that Kelly would instruct Brown to invite girls aged 16 to 20 backstage. Government's response. The government does not anticipate that individual B will testify that Brown helped Kelly invite girls backstage. The motion is denied as mute. That's six. Okay, let me see. So again, they probably does not have concrete evidence of such allegation. So let's go. Let me see what I'm on. Page 9. Goddamn, it's taking a long time. Brown motion number 3. Motion to exclude the government expert testimony from unqualified witnesses. I think this is about let me see. Brown argues that any testimony about child pornography generally and typical offender behavior must come from a qualified expert witness. So this was the part in Brown's motion that the remember she said like trying to say like the officers can't be saying, like saying, yeah, this was child pornography or whatever. Although I believe they could testify if they were part of the investigation. That's standard. They're part of the investigation, yeah. But to make a determination that they knew for sure, like like an expert would do, that this was child pornography based on the development of the girl depicted in the video and all that other stuff, and the way they act and all of that, the mens rea and the actus rea of no, I don't want to say that, but the because I'm talking about the victim, the the mentality and all of that. Then they assumed that that was a minor, whatever. So yeah, it says right here. It says the government response. The government does not intend to introduce such evidence, and so the motion denied is mute. Is that six for Brown and Mary Judge knocking it out? Let's see. So the expert witnesses that will be taking the stand, if they have some, with regards to um, it's a typical offender behavior, must come from a qualified. So and also as well as someone can get up there to testify about how an offender, how R. Kelly, his typical behavior is one that suggests that he's uh, a pedophile. Let's use that word, pedophile or whatever. That has to come from an expert. All right, so that means we're gonna see a CV that an expert will testify on this topic about child pornography if they if the government puts forth one, or if or also if the defense put forth one with regards to child pornography. So let's see. I think that's six for her. Brown motion number four. Motion to preclude government witnesses from providing summaries or statements from interviewed witnesses for a non-testifying individual. Let's see. Motion to preclude government witnesses. Okay, let's see. Brown moves to exclude any statements from non-testifying individuals that violate his protections under the Confrontation Clause. Remember, we talked extensively under about the Confrontation Clause. Wait a minute, I got something else. Hold on, y'all. God damn. Hold on. I don't know what that is, so, but I'm not gonna stop right now to see. 1 minute. Okay, so it says, okay, I'm sorry. Brown moves to exclude any statements from non-testifying individuals that violate his protections under the Confrontation Clause, right? That's somebody that's getting up on the stand to prove something, right? So that's what testifying means. It says the government states that it will not introduce testimonial evidence from non-testifying individuals. So the evidence, so the statements that they're going to submit, they're trying to get admitted, won't be used to prove something. Therefore, they're saying that it won't be hearsay anyway. Okay. Because hearsay is a statement that is offered to prove the truth of the matter, asserted in the statement. And so that means that the statement, as well as the fucking facts must match. So again, if I say I beat up um Dana J on Tuesday and it was raining, that's what I have in the statement. That's what had to happen. I beat up Dana J on a Tuesday when it was raining. So that's it has to match. Okay. And this said the motion is denied as mute, right? So probably he denied it as mute because he knows that it's not hearsay anyway, okay? Because it's not being introduced to prove, sorry about the fan, it's not being introduced to prove what is asserted in the statement. So that's probably why it's denied at mute. So is that seven? Go on, Mary, go on, Miss Judge, go ahead on. All right, Brown motion number five. Motion to preclude the government from making golden rule or arguments to the jury and the defendants. Brown argues that it would be improper for the government to ask the jury to put themselves in Brown's shoes. That's what golden rule is. And the government says the government does not intend to make this type of argument to the jury. The motion is denied and mute because you can't do that anyway. All right, that's what is 7 or 8. Y'all keep up. All right. Now we're going to see how J-Bo does, because this is Kelly's motion. Uh-oh. Oh, let me go check on y'all. I got to go get me something to drink. Come check on y'all. Where we at? Come around the front. Where we at? Where we at? Let's see. Let's see. Let's see. Okay. Okay. All right. We doing good. Let me go get me something to drink. I'll be right back. Give me a minute. All right, sorry about that, child. And my people play shit in hell. They don't be having no goddamn all my little shit I need. So let me see. All right. Okay, so y'all good? Let's go. See what J-Bo's do. Let me see how J-Bo fans. What Mary got by 7? Okay, let's see. Kelly's motion number 1. Motion to exclude certain other bad act evidence. The motion is broken down into several subparts as seen below. Kelly's motion number 1A. Motion to exclude evidence related to Kelly's marriage and alleged sexual relationship with Aaliyah. Oh, it's coming back up. It says defendant argues that he is not charged with any conduct stemming from this relationship. Thus, it is inadmissible. Government's response. The government states that it does not intend to introduce any evidence on this topic in its case in chief. The motion is denied as mute. So they got one. All right. So we already know that the government does not intend to introduce any evidence on this topic, right? So that should mean that Aaliyah shouldn't come up in this case. Okay. Okay. Well, let me look at the hold on. Let me look at the question. Where the Kelly's marriage and alleged. I don't know if that marriage meaning Drea or marriage meaning Aaliyah and well, no, okay. I guess it's Aaliyah. It says exclude evidence related to Kelly's marriage and alleged sexual relationship with Aaliyah. Okay, so it is Aaliyah. All right. So nothing about his sexual relationship with Aaliyah and his marriage should come up in this case. All right. So they got one, and the government said they wasn't gonna raise it anyway. So we got J Bo with one. Yeah, something. I hope y'all keeping score. All right. Kelly's motion 1B, docket number 221. Right. Says motion to exclude uncharged allegations of women who claim that defendant abused or mistreated them. Uh-oh, this might be a big one. Defendant argues that any uncharged allegations should be barred. Defendant asks that the government immediately disclose any such evidence if it intends to present it at trial. So this is a two-part. Government's response. The government states that it does not intend to call anyone not identified in the indictment to testify about Kelly's abuse. Okay. Now, abuse could be physical or sexual. If it's sexual, then you're probably not looking at any uncharged acts. Well, let's go. The government states that some of the minors who would testify might state that others were present during Kelly's abuse, which would be direct evidence of his allegations in the indictment. Okay, so this could mean this. This could mean that they're going to have some other witnesses that's going to testify that the victim witnesses or the victims, the alleged victims, that's already indicted, that's an indictment, were abused, and they know about it. You know, they saw it or they were there, what have you, right? Or or it could mean that testify state that others. There's some minors who would testify may state that others. Okay, wait a minute. The government, hold on, scratch that. Wait a minute. The government states that some of the minors who would testify may state that others. Okay, wait a minute. Scratch that. The minors that would testify may state that others were present during R. Kelly's abuse. So they may name other people that were there, which would be direct evidence of the allegations in the indictment, which is absolutely correct. That's absolutely correct. Of course, they will deny that. This is direct evidence. Of course, he's going to deny that. Okay, so she didn't get that one. How many she got so far? Yeah, I hope y'all keeping count. Does not intend to call and identify and does not okay. The government states that it does not intend to call anyone not identified in the indictment to testify about Kelly's abuse. The government states that some of the minors who would testify may state that other people were present during Kelly's abuse. Okay, so I don't know if they're talking about minors that are already in the indictment or minors that they're coming in as uncharged as people that's coming in to testify. Not no, let me say uncharged acts. It could um let me see. That means there'll be somebody that's coming in to testify that said that they were abused. So let me see something. The defendant argues that an uncharged allegation should be barred. The defendant asks that the government disclose any. Okay, the government states it does not intend to call anyone not identified. So okay, so no uncharged acts of Kelly's abuse. Okay, and then the government states that some of the minors who would testify may state that other people were present during Kelly's abuse, which would be direct evidence of the allegation. So, okay, so he denied it as mute. So that tells me that the people that's already indicted, that's already in the indictment, may testify that other people were present during Kelly's abuse, which is direct evidence, which is why he denied it as mute because it really don't make any sense. Because they're going to take the stand, they're going to and what they say, if they say somebody was there who saw it, and especially if whoever they name who saw the abuse is there to take the stand as well to corroborate that they did see them be abused, all of that is direct evidence. So this would be a mute point. Um, but the big thing is that the government says it does not intend to call anyone not identified in the indictment. So that most likely means that they're not going to call any uncharged acts, but it could change. And if it does, then it says, I think the defense that they requested the government immediately disclose any such evidence if it intends to present that at trial. So we got to kind of watch out for that because I'm kind of wishy-washy on that. I don't know if that means that they're not calling uncharged acts at all or uncharged acts that is talking about um see, the abuse can go either way. Oh, you know what? It would be sexual abuse because domestic violence can be in sexual abuse. So the the abuse and when the abuse can be general. So the government states that it does not intend to call anyone not identified in indictment to testify about case abuse. So it seems like they're saying that at this point they don't intend to call any uncharged acts, and that's a smart move because that could come back to bite you somewhere down the road. Because you got uncharged acts, you got videos, you got the people in the videos and all that shit, you got the conspiracy and all of that. That could be together, could be prejudicial to a jury, and you're not supposed to prejudice the defendant. So that's probably a smart move. All right. So what Jabo got two? Wait a minute, no. Well, that's a win for her, even though the she lost. I mean, the judge ruled against her, but she actually wins that. I'm gonna tell you why, because it's direct evidence, so it's admissible anyway. So when you have somebody that's testifying about abuse, and it's coming in and as direct rather than circumstantial. So she wins that. She loses for as he denied it, but he denied it as a mute point. So she wins it because one, the government and the government response, they said they don't plan to do that anyway. So she does win that. You can look at that as a win. Okay. So Kelly motion 1C, motion to exclude evidence that Kelly impregnated any accusers and or facilitated their abortions. Kelly argues that this information serves no legitimate evidentiary purpose. Let's see. Government's response. The government states that it does not intend to introduce any evidence on this topic in its case in chief. This motion is denied as mute. So again, this is one of these situations where, okay, she loses on the ruling, but she wins with regards to her case. Okay. Just by the nature of that particular, um, circumstance right there. And let's see, Kelly motion 1D. Motion to exclude evidence that Kelly infected any sexual partner with the herpes. Let's see where we go. Kelly argues that this information serves no legitimate evidentiary purpose. Oh, okay. Wait a minute. The government states that it does not intend to introduce any evidence on this topic in its case in chief. The ruling was denied as mute. She again loses, but she wins. Now, this is good, okay, and for R. Kelly because you don't have the herpes stuff in there and and you know what I'm saying, and some of this other stuff. So that what makes me question is if the government isn't intending on piling all this in to bolster their case, then what the fuck do they have? Not saying they don't have anything, but they must be have enough without any of this information that they believe that will get secure them a conviction. I don't know. I don't know what they have, but this is a lot of stuff that they're saying, we're not bothering with that anyway. So we got what we need, and we think that that's going to be enough. Let's see. Kelly's motion 1E. Motion to exclude evidence that Kelly was previously sued by accusers and or settled lawsuits brought by those accusers. Okay, now this is a big one. Oh shit. Let's see. Defendant argues that such evidence should be barred to the extent it only goes to his bad character. Defendant argues that such evidence should be barred to the extent it only goes to his bad character. Let's see what it says. The government argues that such evidence would not solely go to Kelly's bad character, but rather as direct evidence of some, I guess, of the allegations, I guess it's supposed to say, in the indictment. Okay. Now, was some of those lawsuits dealing with the herpes? I don't know. Or was it dealing with just some type of sexual abuse? Which would include non-consensual sex, child pornography, shit like that. I don't know. The government argues that such evidence would not solely go to his bad character. Okay, so they can use it to show his pattern, his alleged patterns, and to corroborate some of the allegations in the indictment. So we kind of get an idea of how the prosecution is formulating their case and what they are using, the basis that what the the particular piece of evidence, particular piece of evidences that they're using to form their case, the basis for their case, and their proof and all of that. So I think Chicago is going a different route, where New York seemed to think that it was the more the merrier. Give them the uncharged acts. Give me all this other evidence, the videos, the this, the that, the the bus drivers, the story. The managers. Yeah, maybe they are going a different route. They look like they're doing some old grassroots type shit. Like, we're going to give you these videos. We're going to put these people on the stand. We're going to show you this pattern of behavior. We doing old school. Okay, let's go. So let's see. So that was those lawsuits and shit. That was a big loss right there, in my opinion. That that they're gonna allow that in. That was a big loss for the defendant. It says Kelly motion number 1F. It says motion to exclude video recordings of sexual acts that do not involve the charged conduct. Uh-oh. Kelly argues that other video recordings should be barred. The storage. Government's response. The government states that it does not intend to introduce any evidence on this topic in its case in chief. Uh-oh. The motion is denied. Wait a minute. So that's a ruling on the ruling tip. That's a loss, but that is a win for J-Bo. Let me see. Let me look at this. Okay, motion to exclude video recordings of sexual acts that do not involve the charged conduct. So extra videos are not included. Uh-oh. To exclude video recordings of sexual acts that do not involve the charged conduct. So that could mean that if they saw what they perceived to be minors on tape, but maybe and it wasn't introduced because they couldn't identify them, or maybe that particular person didn't want to take the stand. It also could be video tapings of just some weird freaky sex with people that are consenting adults. But that could squash that 100 devices that's supposed to show up in Chicago. I don't know. But my goddamn rate over here is pretty good. Pretty good. Pretty good. Let's see. And the storage ain't showed up yet. We still got them 4 videos. I'm just saying. But that don't mean that they might not be stipulated to, somehow come in as extrinsic evidence or what have you. I'm not saying I'm not leaving that out. But and there's no indictment that has been superseded. So, and we're on 8-4. I'm just saying. My rate is pretty good. All right. I'm just popping my own shit. Okay. Because everybody else do shit. And my rate is high. God damn it. Let's see. Stop fucking around. I don't like bragging. All right. Kelly motion number 1G. It says motion to exclude Kelly's prior conviction. Uh-oh. Let's see. Kelly asks that the government be precluded from introducing evidence of prior convictions, including his conviction in EDNY. Judge Ann. As government response, the government argues that limited testimony about Kelly's prior convictions should be allowed if he testifies, specifically Kelly's racketeering conviction. Ruling, the motion is denied as to Kelly's recent racketeering conviction. So, that means that if he testifies, that they can introduce his conviction with regards to the racketeering. So most likely he's not going to testify. So um, I'll get it to J-Bo. And here, even though it was denied, I mean, chances are most likely he's not going to testify anyway, unless he crazy, So I'll give that to Jay. But it's really shouldn't be a point given to nobody because it's like okay, so let's go. And that is it with that. All right, let me take that off. And something else came in. Let me see. Hold on. Let's see what that is. Okay, this is in Illinois. Child, y'all got me work day and night. They say that they say that, and that was the ring. Yeah. All right. Yeah. Come on. Lisa told me to tell you, hey. All right. All right. Thank you. She go with those big old niggas. They be together all the time. What? Hell yeah. Lisa ain't got no teeth in my damn mouth. Yo, you saw Nisa? Huh? You saw Nisa? Nisa. Oh yeah, you saw her? Yeah. Oh, okay. Oh, okay. I got me a package. Okay. Now we got. Hold on, I'm trying to pull up Illinois. I just can't stay away from you, baby. Yeah, 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 yeah. I just can't. Okay, wait a minute. So, hold on, y'all, because it could be under somebody else. Hold on. Let me see. Okay, so it's not on the Kelly. Let me see if it's on the McDavid. Hold on. How y'all feeling out there? Sound like I'm in a concert. How y'all feeling out there? Hold on. I'm not around the front. I got to go and find it. Damn, what? Hold on. Let me see if it's on McDavid. It's not on McDavid. So is it on Brown? Bring him over here so he can help out. Hold on. I'm sorry, y'all. Looking for what came in. What was that? It came in there. Hold on. What was that? Hold on. It's 250. So, is that what I'm reading? Yeah, that's what I'm reading. Okay, well. Sorry, y'all. Wait a minute. What time is it? Okay. Check this account. Hold on. I'm sorry. I'm coming back. I'm coming. I'm coming. Eyes old. Damn, Alex Jones. What is this? What is this? What is this? Let me check. Okay, well, let me come on around there and see what y'all doing. Something came in. All right. All right, I'm around the front. I'm around the front. What's good with it? What's good with it? What's good with it? I'm around the front. What y'all think? What y'all saying? Y'all, I know y'all gonna leave me a whole bunch of messages. I'm gonna get to them. What y'all think? What y'all think? They did pretty good, right? They did pretty good. Let's see that. Oh, man. Old Mary Judge did good. I like old Mary. Told you that motion was decent. I told you. That's why J-Bo jumped on it. On 2 through 5. Told you. Told you. I told you. Like old Mary. What y'all think, honey? Let me drop this sound. Let me drop it. Let me drop it. Funky ass link. I want to make sure that everybody understand what I was saying. Get my girl while I'm over here. Let me see who else supposed to be. Club Blue. Who else? Who everybody's straight? Now whispers. Okay, everybody good, everybody good, everybody supposed to be blue is blue. And okay. Alright, I done pinned it to the top. If anybody wanna come in and say anything, that was pretty much straightforward. Now I will today be listening to see how some of my faves, I ain't gonna call no names. Shit. I wanna listen to how they what they get out of it, how they break it down. I may have missed something. They may interpret it totally different. I just want to do that. You know, I give credit what credit due. Mm-hmm. So, little different ball game, right? Little different ball game. Now, looks like those statements are coming in. It looks like the judge has pretty much determined that they are not hearsay. And non-hearsay is admissible. When I say and when it says that it's admissible, that doesn't mean that it's automatically it go in. It's admissible if it's relatable, reliable, and relevant, right? Okay. All right. So it's so important that I mean I know majority of us people we rely on what the what we say, the people that's reading and breaking down whatever it is we're doing, to tell you, hey, it's this way, that way, and that's fine. That's fine. But I also like to give the now I got to had to add another word, child. Read and breakdown and analysis. So I have to give the analysis, the read and breakdown analysis of it, the RBA of it, because I need y'all to understand why something is happening. So you'll know whether it's just or unjust. You know what I'm saying? Because I know a lot of people think that, oh, she's biased or the judge was biased or whatever. No, like I told you, some evidence they have to admit because it's admissible. They their personal feeling they can't even play. They could strongly hate somebody, they could strongly love somebody. But if the evidence is inadmissible, can't allow it in. Because one side is going to object to that and they're going to take it on up, kick it on up the chain, and then somewhere, somehow it's going to be an issue if somebody is convicted or whatever, whether a post, during the post conviction phase or whatever. So they have to admit evidence that's admissible, and they can't admit, they don't suppose to admit evidence that's inadmissible. This is how it's set up. That's the law. Um, I believe that based on this motion in limine, it behooves the defense team, all three, to come to some type of some type of cooperation, right, with each other. They gotta like each other because if you look at, I can kind of tell how and I'm gonna go back and look at it so I can get a good a good understanding on what the prosecution's case mainly is going to consist of, what points they're going to push, and what evidence they're going to use to make those points. So, and based on what I see so far, the defense, all three of them, they got a fighting chance. If they looked at that motion and the judge's order, they should have felt some sense of hope that they can get in there and defend their client. You know what I'm saying? Their clients. Because the prosecution said that, well, they don't tend to do this, do that, and whatever. Well, shit. Had it been New York, think about it. Had it been New York, and New York was armed with all that shit. New York had that shit and put your ass on a goddamn octopus. New York, like shit. New York use the scraps off the goddamn floor. Give a fuck. Chicago, like, we gonna kind of play it because maybe they don't want to in run the risk of stuff being too much being prejudicial, and then securing a conviction during the trial. But as the case prolonged during the post conviction phase, shit, somebody overturn it because it's too much. Got a good idea that those 100 devices, all that video footage, think it's gonna show up. Or when they process that storage, it didn't produce what they thought they had, or they, like I said, they couldn't identify those people, or maybe they didn't want to cooperate, or maybe the government simply said they don't need all of that. Maybe they think they have enough. And usually, if you have some tapes of somebody committing a crime and a motherfucker in there saying that they was them and when they were underage and he wasn't, he was older and all this and whatever, then that's usually enough. You don't need overkill. I think um, some defenses were shut down, and I think the prosecution neglected to pursue every possible avenue it could to prosecute him. You know, so this should be it's something like an evenly matched trial. You know what I'm saying? You know, it won't be like the the old Bulls when Michael Jordan was there playing the old Golden State. 'Cause back then, Golden State was known as a team that your ass just coming in the league, you get on that sorry ass team, or your ass about to get out the league and you get on that sorry ass team. But that was a sorry ass team for a long time. So we got that going. Mm-hmm. What y'all think? Damn, that little bit of page. I done took a short amount of time with more pages. I guess I did a lot of goddamn breaking up and breaking down. Hold on for a minute, y'all. I saw where Brittany Griner was given 9.5 years in Russia. What the fuck? I thought that God, I mean, like, did they even get? Because there's a white guy that's been over there for 3 years in some kind of work camp. He done lost all kind of weight, and the family was hopeful that when I don't know if it was someone from the ambassador, the U.S. embassy, or was someone that's coming directly from over here that went to Russia to intercede and see what was going on. They were going. The main priority was Brittany Griner, but they were also gonna supposed to talk about the white dude as well. And I don't know. And when I heard that, it was supposed to be like they were hopeful that they were going to get her out of this shit. Well, at that 9.5, I mean, shit. What you mean get her out of it? 9.5. Hell, I mean, what you doing? I mean, unless you mean doing 9.5. If you done been in there for 9 days, that's time served. Like, what the fuck? That ain't getting her out. That's crazy. Wait a minute. Wait a minute. J-Bo pissed they took 2,800 out of R. Kelly's account. She had a fit on Twitter. Oh hell no. Let me see if I can find it. Now, y'all, I suck at locating that lady's shit on Twitter. So let me see what I can do. Hold on for a minute, y'all. Okay, and just to be 100% clear, now let me see, what is it? Jen, Bonjean Law Group. And just to be clear, right? Whatever tapes that was referenced in the transcripts in New York, okay? I held my ground by the 100 devices, the tapes, and all that bullshit, whatever. Um, what they said they saw, they it was notated somewhere during that transcript, either as some type of evidence that came in, and you can go back through and look, because the government was said, you know, this visual depiction, videotape, or whatever, of government evidence, government exhibit, blah blah blah, you know, that, or it came in as a stipulation or whatever. To my knowledge, I think that it was somebody getting yelled at. I think it's a couple of pictures from Geronda. Well, it wasn't on a whole bunch of videos. And the jury saw whatever was notated in the transcripts. It was no secret video meeting they had. All right. It has to be on the record. It was on the record. Don't let nobody tell you nothing different. There was a whole bunch of videos that wasn't seen somewhere that only the jury saw. That is incorrect. The jury saw what was notated in the transcripts. And if it came in as a stipulation, then that should have been notated in there. If it came in during the testimony, that means it was interesting evidence. Get it right. That means that the person was on the stand, the evidence was introduced there. If it was extrinsic, it means that it just came in somewhere at the end, maybe as a stipulation. But it seems like to me it ain't no gang of tapes, iPads, and all that shit or whatever. It could come up. I'm not saying it could come up in Chicago. It wasn't in New York. It could come up in Chicago. And whatever the jury saw is on the record. And if it's on the record, that means it's in the transcripts, notated somewhere. So you go back and think about who took the stand. Who was supposed to take the stand as well. That evidence could have been admitted if they had a tape, you know. So I hate misinformation, Jesus. Okay, let me see if I can find it. Let me see. Okay, she got Bill Cosby up here. See, I don't know how to use this goddamn Twitter. Somebody have to send it to me because I don't know how to do this shit. See, that thing say May 24. I don't see no but let me come around there where y'all at. Did someone send it to me? Oh, wait a minute. See, my goddamn whistles be whispering to my ass, baby. They know I be struggling, baby. They know I be struggling. Oh, wait a minute. What I got? Okay. Hold on. Thank you. They know I be struggling, baby. I don't know how to use this shit. Let me see. Where we at? Where we at? Let me see. What was this sent on? Okay. Yep, and they sent it out. They know how I like it, how I can get. Thank you. Let me see. No, I was struggling. I'm up here pulling up shit by Bill Cosby. That's the only thing I see on her thing. Got shit by R. Kelly up there. I do not know how to use no damn Twitter. Oh, I got me somebody coming on through. What's good with it, DJ Amazing? What's good with it?
And I'm gonna say it again.
What?
On it.
I can't hear you. What?
I think he got 9 motions in so far. I think he got a good chance of winning this thing.
That I don't know about that. Um, Gotta look at the weight of the evidence. Well, hold on. Let me read this about Jay. Okay. All right. Okay. It says this first thing I got. It says okay. After this article was published today, okay, the BOP confiscated the majority of Mr. Kelly's funds, trust funds today with no notice to him and without any court order. As you know, the EDNY judgment is on appeal before the Second Circuit. Please advise whether you have any information regarding what authority exists that allowed the BOP to confiscate his money. Where did the money go? Was a receipt provided to my client? Please provide any information available about the taking of Mr. Kelly's funds without even any notice. Honey, I notified you. I told you when they take it, they're gonna give you an order. Uh, you know how? Well, okay. Let me stop messing with J. Bo. You know I love you, girl. Let's see. More importantly, I want to lodge a formal complaint against the BOP because I have learned that a BOP correctional officer unlawfully accessed Mr. Kelly's trust account again and shared that information with this journalist. As you know, there was already an investigation into a BOP officer who unlawfully accessed private information from Mr. Kelly while he was housed at the MCC and shared that information with the YouTuber who published the information to the public. This is a federal crime, as I'm sure you must recognize. This needs to be addressed. Please advise who is responsible for taking this complaint. A prompt response would be appreciated. Okay, let me get to the next one. Hold on. Thank you, my whisperer. My whisperer. You know I suck at this. Okay, let me put this up here. Hold on, DJ Maze. I'm sorry. Let me put this up here. All right. Okay, this is from J-Bo. Could the government be more unethical after seizing his funds and after sending this email? EDNY News decided to file a motion to confiscate his trust account money. You're supposed to do that before you take the money. What were they holding it in? Okay, that's the same thing. Okay, that's her. Child, she is hot. J-Bo is not playing the radio. Okay, that's the same thing. Yeah, thank you so much. Yeah, so she was hot about that thing. And I mean, listen. So I'm gonna tell you why they eased it like that, right? Because had they given a notification that on a certain date we are going to confiscate your funds, let me tell you something. before we're professional, before we're rich, before we're, you know, bougie and everything else, we black and we niggas. We would have moved that money so fast. when they came to put that motherfucker order in to confiscate, it wouldn't be nothing there but what? 25 cents. Okay? Let me tell you. Let me tell you. Okay? Now see, now this is what y'all done now. Now y'all done set Sylvia up to come back to cuss y'all out on that back channel. See? I told you. Now look. Sylvia cussing out, baby. Get that ass, Sylvia. See what I'm talking about? Oh Lord. Yeah. They been Sylvia cussed their ass out on that back channel. I know when that back channel light up, baby. I know she gonna be cussing back there. See what happened? Listen to y'all. Listening to y'all, see? Now all the money gone. $28,000. I wish a motherfucker would take $28,000 from me, baby. I would come on here. I would cuss everybody I think I don't like out. Oh, I'd be mad as hell. And they left the man $500. $500. Yeah. Right. Man, $500 out of 20. You, huh? Listen. If somebody took my $28,000, right? And if I was R. Kelly, every guard that come around there to do count, the nurse, I'll be putting slips to see the warden. Somebody will have to tell me something. I'll be in there showing my ass. They be like, R. Kelly, you gonna sing? Hell no, I ain't singing shit. I'm singing, bitch, better have my money. That's what I'm saying. Bitch, better have my money. What the fuck? Huh? 20? You done took my what? I took these good people, these good citizens of America's money. Took my goddamn my y'all. I'm saying, bitch, better have my money. Okay? That's what I'm saying. My damn money. You stupid. Well, yeah, all the BOP accounts are set up as an inmate trust account. So, but when I told y'all, I was like, send the money, go and send the money. But when they go to confiscate the money, they have to have an order to do that. Right now, but it should have been a process to where it should have went on freeze first. So I don't know if it is on freeze and they're just using it, using a different word. It's on freeze, and then when they get the order, then they'll release it to the Department of Justice so it can, apply it to whatever outstanding. Account when they have an account for someone in trust government fund, the same type of trust hand that holds the child support monies. Right. You're right. It's a trust. Mm-hmm. Yeah. So now y'all, DJ, you still there?
Yeah, I'm still here.
Okay.
I'm still here.
So you know what now? You know what I want to do, since I'm such in a, y'all really got me in a better mood today, because I really was, woo, baby, I was gonna have a lighted up tour that was gonna be in the title. Light it up. Send your ass to the motherfucking moon. But I want to pull up the transcript, right? I want to find them motherfucking 100 device. I want to see exactly what came on up. Hold on, let me see. See if I can find it. Man, 20. I mean, yeah, listen. If I must say so myself, Y'all supporters, y'all know how to look out for a nigga. 28 grand? Shit. When Levi get finished putting us all in jail, I hope to have something like that on my books. I know my people gonna look out for me. But I'm looking for the YouTube community. Hook a sister up. Sure, y'all gonna be in there with me. Never mind. Oh man, I took that man 28 grand. Baby, they done took your money. Baby, they done took your money. Hold on. What the hell is this? Hello? Hello? You have the wrong number. You one of them motherfucking modernized robocalls. Let me tell you something. Y'all get them robocalls when you know that it's an automated man and you say you got the wrong number, and then somehow his automated ass be like, oh, so maybe you can help me. And I'm gonna tell you how you know that he's an automated man. That's one of them modernized ones. They put that 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 I forgot what the technology they use. You could keep talking to his ass and shit. He keep talking over your ass. He want to modernize. Ain't no Jeff him. Get your ass on. Oh, maybe you can help me. That's what they do. I ain't on the screen, y'all. Yeah, they probably asking R. Kelly talking about some songs and shit. Now, I mean, so how is that girl going to be able to make the bills? You know what I'm saying? Shit. Silver gonna cuss y'all out today. I'm trying to tell you what's good with it. Progress 2 times. Listen, Sylvia and even Pastor Peter, they gonna they gonna cuss y'all out both in English and in African. They gonna cuss y'all out today. Cause they had it set up. And here come y'all asses done messed up the goddamn the money. Boy, I'm trying to y'all always messing up the money around here. Now I did say if y'all in doubt, send it to the jail. But I also did tell you, in order to take that money, they're gonna have to put in an order, but they must be frozen and point there. She does. Unless they got a notice that's saying, oh, wait a minute. I'm trying to tell you how they're gonna get out of it. I guarantee you, somewhere when they issued that judgment, they said they described what kind of funds can be seized. So that was the notice. That was your notice. They described what kind of funds could be seized. Now, if you didn't think it meant the inmate trust fund, that's on you. So they probably gonna say that was our notice. We told you what type of funds could be seized to satisfy our, fines and judgments and all that shit. That's how they're gonna do. Mm-hmm. Hello? You still there, DJ Mason?
I'm just listening to you whenever you're ready. I'm listening.
Okay. Well, Cotton Candy talking about she don't hear nothing. What's up, Lady T? Yeah. Cotton Candy, I don't know what you doing. Hold on, I'm trying to we're gonna find about this motherfucking tape. Once and for all, we're gonna find about these videos. What the fuck did they see? The jury see? Because I'm telling you, it will be referenced in this goddamn transcript. I'm just waiting for them to come up. But yeah, R. Kelly sick to his goddamn stomach. Shit. He probably thought, yeah, I can buy 10 bonds every commissary day for about 2 years from Slim Jims or whatever the hell they got on there. And now he got $500. Now he just like the regular people in there with $500. Shit.
I guarantee one thing: if they unfreeze this nigga money, this nigga finna get that. Bajin gonna hire some of the best motherfucking lawyers money could buy. Watch what I tell you.
Why would he have to hire the best lawyers?
Outside of Bajin, he gonna need some more shit. She good. Don't get me wrong, she good, but he gonna need some more firepower in that courtroom. If he trying to get an acquittal.
No, because she has her own staff. She has her own staff. You really don't need how she got it set up. Hold on. You really don't need I think she pretty much got it covered, because unless it's some other kind of specialist like her who specializes in in rigorous defense like that, trial attorneys like that, and can definitely have her experience like with appeals and stuff like that, but
well, the reason
appeals
I said
even
that,
harder to
the
get.
reason I said that, because like you said, some of the motions he lost, and some of the motions you can't just overlook neither. Some of those motions were big motions.
What you mean some of the motions he lost when?
Some of those you were reading earlier, some of those motions I was hearing you, listening to you,
Oh,
the
okay.
evidence.
Oh well, yeah, but see, I have no idea why y'all under the understanding that you got to grant a certain amount of them. No, if it's here's the difference, right? The motions that were written prior to her taking the helm, you could tell that they were a client driven motion. Those motions, 9.9 out of 10 times will be denied, because it's based on your client's emotion. When it's a attorney driven motion, you have a better chance, because the attorney knows, according to evidentiary rules and all of that, what's most likely going to be approved, could be granted, and what's not. Your hands are kind of tied if you have a client. The client knows he's in charge of his defense. That's pushing you to put in all that. Hold on, something else coming. Hold on. Let me see what this is. Okay.
Well, while you read that, some of those motions you were reading, it seemed like it's gonna do more damage than help.
Hey, oh Lord, I'm on the ground, I'm on the floor. Hey, Sylvia just goddamn went live, and her title said, "Next time, listen." Oh, Sylvia. Sylvia said, "Next time, listen." Wait a minute, and she's not on her back page; she's on her real page. Shit. Oh, I'm on the ground, y'all. Oh, y'all, I need that laugh for the day. Sylvia, like, I'm about to goddamn invade her goddamn live. That shit funny as hell. Sylvia said, "Next time, listen." Sylvia. Oh, shit. That's so damn funny to me. Oh, my goodness. Oh, no. Oh my goodness, that's too funny. Sylvia said, "Next time, listen." I said for you, Sylvia. Next time, listen, bitches. No, y'all around in this segment, y'all managed to elect The dumbest motherfuckers to be the leaders and the goddamn talking heads and shit. The slow motherfuckers. I don't know how this works. Then you get mad at the people that got a couple sense, common sense and a couple goddamn sense. I don't understand how this works. This is the most backwardest shit I ever seen. Oh my gosh, I'm on the ground. Thank you, Star. City said next time, listen. Oh shit. Oh, I'm on the ground, baby. That is funny as hell. Hold on, let me see. Let me see if I can find um how many video, where the videos came in at. You gonna hear. Okay, anyone's supposed to be about the dependent. I made a YouTube video. Who is this? Deronda Pace. Let me see if I get it. Let me see if I can get it. Okay. Video is mentioned in 20. Okay, let me see if I can get it. My pen. We're gonna do this. We're gonna squash this goddamn thing once and fucking for all. I tell you, duck and pull a truck, shut up and hook the motherfucker up. It ain't there. It's gonna be in Chicago. Okay. Don't seem like it's gonna be in Chicago. Hold on. We got video mentioned on let's see, we got 20.5, 32.25, 36.16, 36.17. Oh man, I am hollered. I ain't got that notification. Oh, that made my day. So we said, next time, listen. Oh, Lord. Oh, I got to listen to that. Oh, I got to listen to that. That's funny as shit. She is sick of it. She's done. Oh, man. Oh, that was it.
So let me ask you this: do you think everything in this case is looking on a level playing field this time, or you think he gonna get railroaded again?
I think it's on. I think it's pretty much evenly matched, just based on what that motion and limiting. Like I said, the motion and limiting is where your case starts to form up. You know what I'm saying? It's they either shutting down defenses or or shutting down the prosecution pieces of their case. So, you know, I don't think he got railroaded last time. I mean, it was it if you're talking about was it too much, I'll go along with that. Was it it could have been kind of considered prejudicial because of the amount of what they had, but I mean that's what they had. That was the evidence of what they had. So why not? They couldn't really. Okay, the government was shut
Yeah, but
off.
it was not proven. They didn't have, they only had here a lot of that shit. Last case was a lot of hearsay. They had no
No, no,
physical
DJ, I'm
physical
out.
evidence.
DJ, please
In my
listen,
opinion,
listen.
I'm gonna listen though.
Okay, you said in your opinion. What I'm talking about, okay, because now just make sure because when you start talking about proven and hearsay, please don't use the word hearsay unless you know exactly what that means. And proven, I'm talking about what the jury. Now, I'm not my opinion. I'm talking about what the jury said that was proved and what wasn't proven. The only thing they said wasn't proved is that Sonya girl with that bizarre story. Now, I would definitely agree with that. But you know, hearsay, it has a specific meaning. What you mean is rumors. Say rumors, because when you go to hearsay, you know, that word hearsay
Okay,
is
so what
just
if I'm
like,
using the word preponder of evidence? They did. I feel like it was not central enough to convict him on what they convicted him on. So is that better to say?
yeah, you can say that, yeah. You can say that. Okay, I'm just trying the video. Let's see the videos. That was okay. We got 215, 214, 321, 5, 348, and 349, and 13, 236, and 13. Yeah. Yeah. Camera. Video 489. Oh, I'm gonna be here all day with this shit. I ain't gonna write it down. I'm just gonna keep going through it and see if I can find it.
I think this case is gonna come down to who can put on a better dog and pony show to the jury. Who could put on a better performance? That's how you're gonna know who's
Right,
gonna win. Who could put
right.
on
Who
a
could
better
sell it?
performance?
Yeah, who could sell it?
I don't think
Who
you
could
just gonna be
sell
able to just tell the jury just anything and they roll with it this time around. Now, if he win this case, what happens in this other case? Does that go? Does that other case go away, or he has to serve out them entire 30 years if he
it?
wins this case?
Yeah, he's still convicted for 30 on the New York case. So yeah, he has to do that time. Yeah. Yep, he has to do that time. I'm trying to find out all that video.
So what
Okay.
happens if he win this case? That's what I'm asking. You know, if he wins this case, it just it's not and void.
No, this case don't have nothing to do with the old case. These two different cases. He's
Right,
still
I know
convicted
that. I
for
know
the
that. But I'm
30.
saying if he win, so he basically, if he beat these next two cases, he basically stuck with the 30 until he get an appeal and get that shit
Right,
back.
right, right. Okay, let me see. He told me to send me pictures and a video of me performing. So that's pictures and a video performing. That's at 233 M. So that's a video of performance, not sex. So performance. Video, my friend. Don't find this video. Okay, and anything, how do you respond after your friend received the video? I told her that she can do that, and why did you tell your friend could do it? Because it checks my phone. Government offers 205J, no objecting 205J. Plus, what was that? Jury, please. Attention indicate, and this is a video of my friend Mia. So 205J is a video of friend Mia. We're gonna get down to this bullshit about these videos. Videos and tapes. Oh my gosh, that is so funny. Sylvia, I want to listen in on your live. I don't want you to strike me because I want to laugh. Sylvia says, next time, listen. Oh, Lord, that is funny as hell. Uh, when it was there other recordings, yeah, they were videos of punishments. There's indictment, just that video. Did you make the video? Oh, we don't find this shit. Video. Add about the video. Okay, iPad. Okay. Yeah, I'm showing the witness. I'm showing the witness. Everyone was in evidence. Oh, here we go. What's on the first? That's a picture. That's not a video. Video. Okay, so hold on. What is this? Okay, it says I made a video with iPad. What you do with the iPad? You made it. Then took the iPad and watched the video. How did he respond? He said I wasn't into it enough that I would have to redo it. Did you redo it? I did not. Miss Gay says I'm showing the witness. Sorry, I'm showing everyone what's in evidence and exhibit 926 on this page. What's shown on page 26? This is first a studio of me and defendant was sleeping at times. So 926, exhibit 926 is sleep. I guess a bed, I guess a room or something. Not sex. Okay. In the studio, the video, maybe the iPad. Did you record it? Yes. Still on that exhibit. Okay. Made the video. We watched the video. Okay. The restroom made. Take to left. To the left is the restroom, and where the defendant made me take the video. And what, if anything, did the defendant say about similar video? He said that another girl did the same thing. Who you understood the defendant to mean? The other girl is Neek. Did you ever see the videos? Never. Were there other videos of the defendant? Okay, we're gonna find the videos. Okay. I hear about these damn videos. He testified. There's videos of feces. Made a video of sexual videos of you, including 17. Okay, was there ever an occasion where the defendant showed you videos he made of you, including when you were 17 years old? Yes. Can you describe that? I do recall a few years later he showed me a video of when I was 17 when I recall the same exact hairstyle. Objection, volcanic. Showing you video. Okay, I'm getting through a lot of this. It won't be long, y'all. Videos. Can you sound the video? Find them down video. What is this? Page 1-3. Okay, what is this? Nope. Video frequency. What is your application? Videos. Okay, showing you video. I'm sorry, I'm looking at videos, y'all. Videos like that. Video. Okay. The defendant will show me other videos of women also crying, saying they some things about themselves. And I'm showing what's in evidence of government 76. Was that one of the women you saw in the video saying something negative? So yes. Over the course. Okay. In exhibit 76. Let's see, what this is about. And whose idea was it to say what you were saying in the video? Like you make videos like that after chastising how many occasions. Can you describe the videos that the defendant told you to make? That's describing the video. That's not the video. Okay. So what are you saying? Was that woman you saw? Was that one of the women you saw in the video saying something negative about herself? What is the video? Okay. Okay, and one that was sent a video of you dancing in underwear. Let's get his objection. Okay. Testified the videos. Okay, and you testified that he had videos, iPads during this encounter. Yes. Your Honor, yes. Mr. Kelly, all of you at Christmas. Look at Mr. Kelly taking videos of all of you. Never videotape Christmas video. In fact, he was videotape everything. Trip to the beach, videotape, iPad camera, videotape, videotape. evidence. Your tip wasn't and video. Okay. All right. Oh, I know he. So I know the. Okay, you record recording video. Okay, Miss Ken, I want the government the opportunity to see the video. Okay, hold on. Let me see. YouTube, a type of social media forum where your family spoke for Ms. K. Yes. All right. The following is subject to Ms. Ken. I just want to give the government an opportunity to see the video that we're about to show. I'm sure they've seen it together. Document. It's a document, right? So that's not the sexual video. Okay. All right. Now what is this? Okay. Uh, Turn your microphone off. Yes, ma'am. I did. Okay. Can I go ahead, Judge? Yes. Go right ahead. Video play for witness only. Ma'am, y'all. Okay. Turn the microphone if you don't mind, Miss Candy. Do you recognize your voice in the audio? Yes, I do. Do you recognize this conversation? Yes, I do. All right. So can we take our break? So that video was by the defense. I know damn well there ain't no sexual video. So we're gonna keep on going. Text and stipulate find out about my parents, so I sent him a video of me doing both. They told me what to wear, which ended up being a crop top and tights. They watched me as I made the video and said nothing about it. Okay, can you read from where the yellow highlights? They sent the pictures of me in a crop top. Oh, they sent pictures of the girl in a crop top? God damn. Okay, so my understanding from at least initially, uh, witness to testify by video and to simply have her testify by video. Okay, I think we've got to just testify by video. I have it a few times by video. It's excellent, efficient, and parties going on with the witness. Let's say that testify by video. Okay, allow testify by video. Okay, stipulation. Okay, so what is this? So I'm going to direct the parties to make their best efforts to come to some kind of accommodation, either by stipulation or by video. And we're a little bit of uncharted territory. So here are the terms of what the court can order under these uh, with the health pandemic in front of a hotspot. So anybody need to be heard on this? The government does not. Okay. This trial having no time, as you seem to have getting along pretty well, and it seems to be a reasonable accommodation. So I think, Ms. Kenyon, I just asked if we can have the opportunity for marshals to accommodate, so that we can give 5 minutes so we can start the discussion. Yes, I think we are be gracious to do that. I do think that the marshals, with the time, the hard work, also this trial, also. Thanks for doing that, and yes, concerned to that, and anything else, no. Okay, thanks so much, Judge. Okay, hold on. What is this about? What is the stipulation? Stipulation. Okay, so there's a few additional witnesses. Okay, this is about the witnesses about testifying by stipulation to reach a stipulation on allowing them to testify video. So that's not a video about no sex. That's right. Parties come to agreement by the lady in Florida with minor age girl doing that by video. That's still testifying by video. The objection having the witness testify by video. A warrant defense stipulate to appearing by video. One day, but there's no reason why you can't do this by video. When I was take pictures, many pictures and videos with the man, so you could blackmail him. Okay, that's that. That's talking about the letters. Okay, and trying to get me to take as many pictures and videos as I could of him. Okay, Mr. Can't. There was something I didn't quote my reserving with the ruling with respect to video. I'm sorry, y'all. I'm finding these videos. Okay, Mr. Can't. There was something the court, I think, reserving a ruling with respect to the videos. And I'm going to offer them in. Okay, wait a minute. Was this it? Is this video? Okay, and wellness check. Some action private, but yet correct. You also want to check about Homeland Security. Am I correct? I have nothing to offer. This is something the court want. I think reserving the ruling with respect to the videos. H&I. I'm going to offer them into evidence at this time. Yes, the audios. Yes, the audio videos as well. Do you have objections? As long as I can redirect on it. Okay, I thought she admitted that she made the statements. That's why I'm not sure as to as sure as why they would come into evidence. But Ms. Kent, I think we have. I don't want to continue discussing it because either Your Honor, cyber for a minute, have the reporter Okay, I just wanted to flag the thing. The court, I believe that either you already ruled or the person cost 7 is actually parents tell you to do the 18. And I think it needs to be explained why. No, hold on. Okay. So many is certain reference parents explain. Okay, this exploitation. Um, exploitation. This is exploitation. Okay, we have videos of her twerking on the back. Okay, that's twerking. Do you have a person ready to go, or is it the next video person? That's testimony by video. Testimony by video. And okay, who made you film the videos? If you can engage in degrading conduct, okay, maybe this should be a video somewhere with this degrading conduct. Where is the entry? This should already come in. If this the one with the boo boo, this should already come in. Okay, and the last video you said could nag about sleeping within trying to take as many pictures and videos. Okay, it's a video. Okay, hold on. Now what is this? Okay. Okay, well you're not going to have any more questions for this week. I'm not. How long is it? It's a minute. If it's short. Okay. Do we have to play it now? Okay. Your Honor, nothing further. This plan, correct. The statement is untrue. Plan, already got 1 page of evidence. Exhibit P. It says, okay, what's Exhibit P? It says, once I got there after about 30 minutes, they planned to call the police. Do you think this is where around that he showed us? If this is something specific, beyond the scope, to my Dolphin Hotel, brief your honor. This is okay. Your honor, credit a little longer. Okay, it's a video. I thought we were just playing the audio. Now there's a reason. In the government's view, there's no reason to play the video. She saw the video audio. Can I ask a question over at the side? Yeah. All right. I think under circumstances, just to play the audio. Audio style. I don't know. There's a second video audio style. No, Your Honor. Are you ready to call? I think somebody appearing by video. Somebody appearing by video, and there's somebody playing the audio video. Hold on. Exhibit P. What's Exhibit P? Sorry, DJ, man. I'm finding these goddamn videos. Okay. Okay, is the video just playing the audio? Video. Okay. All right, this is across. I know the video imaging on here. So I thought we have our witness on video. We need a jerk that's a witness on video. Okay, there's a photo where I'm pointing. Do you know what it is? It's a video, and do you see someone face on the video? Yeah, that's Jamia. And do you recall what this video was that you sent Jane? Yeah, it was a video of Jamia and I in the lunchroom where Jane used to hang out. Well, what the hell is this? Okay, there's a photo where I'm pointing down. Okay, there's a video of me and Jamia in the lunchroom. Okay, who is Benadala? I ain't even know nothing about no Benadala took no stand. What the hell is Benadala? Is that your response? And where's the video? Yes, sir. And you say, what's this going to say if you see the video? Objection overruled. Can you repeat it? What the text message? Oh, because I was wondering why I shouldn't send her a video. Okay. Okay. What's your response? Okay. Okay, it's video chat. Read that by video. Okay, our video performances. Okay, it could be a mistake of a video shoot. There come a time with the videotape you engage in sexual contact. Yes, okay, it was their video here. Where's the videos on the iPad? and all the shit from storage. I set a time to meet in storage. Okay. Make a video of us having sex. Okay, he would pick an order to do that. Her have sex. They have a choice. Okay, let me see what this is. Okay. And do you recall and think about the name of the street the house on? Yeah, I believe it started with a G. I'm showing a witness what's in evidence government. If I was do you recognize photograph? Yes, that's the home that we went to. Okay, that's not the sex. Okay. Bill having a sex. Charlie said going through your head. He told me that it would be order to do that. Okay, so I hung up right there with my friend. Mechanics. Okay, so wait a minute. Okay, this is Stephanie. Did Stephanie have some video? Okay, no, he went and quick that video camera and come on. Okay, Lincoln Park. Okay, video camera with there, right? Camera, video, okay, video. What is the video? Video camera, video facing you. Okay, that's not video. Okay. He came from behind and started having sex with me. If anyone was the video camera at the time, it was in front of me. Could you repeat that? Video camera facing you. Okay, nope, that's not evidence. Okay, and where was the video point? Okay, and you testified there was a VHS video camera. Yes, was recording you. Okay, where's the tapes? I'm looking for tapes. Looking for the tapes. Looking for the tapes. Where are... Okay, calling it asking if I can meet with him, get videotapes and destroy them together. Give hope that we could at this point. Okay, kill the videotape a couple times. Said that the videotape used that correct. Interesting. Where's evidence? Stephanie. It's Stephanie. You know, Sonya, you the one that nobody believe. Okay, videotaping. In fact, there's video out there, and you didn't know if any of them were with you. Didn't you do that? Yeah, the video. So yeah, anything about the correct. Okay, destroy them. Okay, what happened to get those videos? Shadow protection. The video is sort of. Oh, I hope Little Crazy don't spaz out because I'm looking for the videos. Jesus. Not that I don't give a fuck because you don't run shit over here. The videos we're talking about, you were not able to supply them. Okay, the videos that you were talking about, you were not able to supply any of those to the government, correct? No, they're not in my possession. Who's it? That's Stephanie. Okay. So, okay. Okay. So about one of the other guys. So, Stephanie, I could really go through yours. I personally did not watch any of the videos that show in regards to the abuse that he inflicts on other people because I didn't want to remember that happened to me. That's Stephanie. Who was Stephanie? Okay, he was a videographer. The defendant, Bubble. Is that Mayweather? Okay, Mayweather talking about videos. Okay, facial videos. Okay, video phone call. It's on the video. Video FaceTime chat, video recording. So that's if I'm gonna go about a video recording that the defendant made of you by you were the student second. Is that right? Okay, okay. And the contents of government evidence exhibit 327A and 327B. Can you read that? Do you recognize the videos in that on that CD? Yeah, I'm sorry. Can you repeat that? Sorry. Do you recognize after viewing the videos on the government CD? Do you recognize what it was taken correct? And did you recognize who was in them correct? And based on your review, do you recognize the videos haven't been taken? They were taken by him on his iPad. They were from his iPad. Do you recognize who is this talking? Fake. Do you recognize who you were correct and who was in the videos of Raquel and I? All right, and objection. Okay. No, okay. Videos of receiving evidence. That is so what him and Faith is doing on this video. Basically, okay, they in the studio. Okay, that's not it. You recognize. Okay. Recognize the based on okay. Who you in the video? Okay. Approximately 10 minutes long. Okay, you testified and have opportunity to record your testimony today, correct? And that was a video approximately 20 minutes long, correct? All that. Who's in video evidence? I'm not going to play a video. I'm just going to play certain portions of it. Okay, Michelle, Your Honor, man, I know. Okay, this is okay. I want to move on. I'm going to remind the jury. I think I told you before with this item of evidence, you'll be able to see the course in the course of your deliberations. But if you move on to something else, we will see if we can work it out. Okay, Mashada. Yes, Chad, I'm not ignoring you. I'm just trying to find some videos. Now, after you just described at the studio, um, okay, what is this? What is this evidence? Okay, so the evidence government 327A and B. What is that? Okay, who was in the video? Objection. Any objections? No. Recognize. Okay, do you recognize? Okay, they're in the studio. Okay, so that's not sex. I can hear him watching other females on iPad. I know he's in the video because I can hear him saying the names of the women on iPad. Now, without saying the names of the women that you could hear on the iPad or hearing things in the video, he was watching. Do you recall the names you heard? Yes. I'm showing witness only what has been marked for identification of government 954. And then I will also show government exhibit 955, showing you the first 954 was the video was one of the names of you heard the defendant say on the video that he was watching, correct? And now showing you government exhibit 955 was the name you heard on the video, correct? I guess I can put this up there so y'all can see me go through this. Hold on. Oh, shit, DJ made it all that. DJ made it. I am not finna sit and watch. Yeah, we're gonna find these goddamn. There we go. Okay. I did not need you to do that. Okay. So the government is not with correct. The government moves to admit. Okay, the evidence to jury only. Okay. Display to jury only. Okay, maybe this may be one. Okay. Okay, and I know he's in the video because of him saying the names of the women who are in the iPad. Now, without saying the names of the women on the iPad, could you hear the iPad or hear him saying in the iPad video and watching? Do you recall the names you heard? Yes, Michelle. I'm showing the witness only on what's marked for identification. Government, that might be one. Hold on. Exhibit 954 and 950. It's showing you first of 954, the vivid names you heard that video was watching, yes. And the government was the video was watching, yes. The government was to admit 954, no objection. The government actually needs. Okay, and actually 954 doesn't need to be to the jury only. Okay, that means they can show it to everybody. You're okay. So now the government 954, is that the name Joy? Correct. And was that the individual that the woman that the defendant introduced you to in Dallas? Correct. Now you testified a moment that you were clenching your body while the defendant was trying to penetrate you. Okay, well, wait a minute. What I got to do with some video? Okay, move to admit. Like, and he got his iPad. He always recording us. He got his iPad and literally started jacking off. What it was like high speed, like the way he was masturbating was like so fast. It was like an itch, like he had to scratch. And he turned the volume up loud. So as I am sitting here, I can hear him watching other females on the iPad, and I know he's in the video. Okay, someone got up the same thing. Okay, so now I send the names of the women that you could see here on the iPad. Here I'm saying on the iPad video he was watching. Yeah, so I'm showing you I'm showing the witness only what's been marked for government exhibit. Okay, so maybe exhibit 955 and 954 may be a video of some kind of sex. I'll do that. I'll write that down. Name on the video. No objection. The name of the woman. They said it got something to do with Joy. Frustrated. Okay. Now, after all, well, you testified that you saw the video of defendant masturbating to the video that he was in using two names. You just addressed right. Okay. And what happened after that? After he told me I needed to be like them and call back. Maybe that's one of the videos. Okay, well, let's give 95, 954, 955. Let's say that's a video. So showing you the person 954. Okay. That was okay. Then he was okay. Masturbation video. Okay. So and you testified earlier that you were sitting in a chair in the room where you saw it masturbate and watching the video on the iPad. Right? Do you see where you were in the room at the time? Yeah. Okay. Right in that corner where the chair is. I'm showing 514G. Is is this just another view of the chair? Okay, so that's a chair. So that's not video of sex. Okay. I think we get to the point of talking about what happened the second day you're in the student and you testified the defendant started making certain videos of you and him. Is that right? Right. Okay. So I think at this point we're having some technical difficulties. I can play them. I want to start with what is evidence government 327B. That might be a video of some sex. Okay, and the test further, you had a chance to review those recordings. Yeah, and the exhibit 210, is that a video that is approximately 20 minutes long? Yes. There's an entire video evidence, but we'll play on a certain portions of here today. So I think all the jurors have headphones. Yeah, but before we get to that point, I want to ask, do you see the screen in front of you, correct? And do you recognize the people in the video? Yeah, it's an evidence. You ask all the videos. I think she testified that she is in the video initiating. I'm not trying to rush you, except I am. I will take your note, Judge. If everyone can turn their headphones on, there is a little button. Oh, this might be some kind of sex. Everybody should have a green light on their headphones. There is a little button on the side. It's a sad day when I'm giving you technological advice. Let us know if it doesn't work, and we'll figure out something out. Yes, about 30 minutes on your video play. It's on everywhere. You don't need headphones. Okay, the court just keep playing. I'm playing both, so keep your headphones on video play. Do you see what's going on in the video at the point? Correct. Could you hear anything about? Could you hear the defendant say, "Fix your legs"? Oh, this might be sex. Could you hear anything about that? No. And did you proceed with "fix your legs"? Yes. Could you hear what the defendant was saying to you? Whenever we get whenever we out in the club anywhere, my legs should be pointed towards another man. Should never be pointed towards another man. My energy should be turned towards him. Michelle, if we could fast forward to approximately 305 video plays, we could stop it. What was it? Can you tell the jury what was going on at this point? He told me to give him a kiss and rub his head. In fact, did you do that direct? Yeah. Did that rubbing of the beard go on for several minutes? Yes. If we could forward to approximately 620. Lost sound. Just play video. Oh, this might not be sick. It might be like rubbing his head and shit. If anything defendant asks you to do to get his phone from him, it's come back from correct. And how many phones does it appear to have there? 3. If we could forward to 10 to 25. I know the sound is not on, but do you see the defendant get up and appear to be speaking to someone? Okay, this is like, is there a curtain behind you in that video correct? Covering that window you testified about earlier, correct? Based on your review of this video prior to your testimony today, were there various points in videos where the defendant said, "Talk to daddy," correct? Oh, it might be sex. Oh, after the point, he said something to the engineer behind the curtain. Oh no, wait a minute, some people in there. It's okay. I like to turn to government exhibit 327A video play. Same location based on prior testimony. We, was this recorded the same day? The video played. When the defendant asked you to do that, rub his top of his head. Based on your view of the video, does rub top of his head look at him? Does that go on for the rest of the video? Correct. I'm showing government jury of what evidence of page government's exhibit 231A item sent to your lawyer in New York. I want to focus on the photograph on the bottom left corner. Do you see that? Do you see the scene in the video where we just watched? Yes, rubbing the defendant's head. Okay, this is rubbing head. Turn to the last page. The defendant to them and testify before the break about text messages. Okay, hold on. That's rubbing head and they out. Okay, make sure the entire video evidence wrong place today. The video of one place in front of today. I recognize people in the video. Yeah, the evidence here. People putting testified about video initiated. I'm trying to Okay, video play, video play. Okay, going on that point, I'm trying to find uh, the 6. Okay, it's 40, 20. I went to that. Okay, I did went to that. Same location, went to that, went to that. Press play. This one probably, this is the same scenario we just watched. It's recorded. Okay, all right. I don't remember saying that. Okay, you know that it was televised. Well, it was recorded. Okay, so stop for half an hour killing. Okay, that's not 6. Okay, one small matter. The witness, I believe, that the next witness is going to testify by video. Testify by video. Testify by video. Screen. Witness on the video. Video. It's your video witness also. Okay, now what's the first iPhone that we had video recording? Okay, the first iPhone video. Okay, let's test one of the iPhones. Okay, and how about iPad? You testified earlier that the first iPad that's okay. Okay, I think the first video is clearly relevant. It comes through the videos. The second one, however, is cumulative. I think it's unfairly prejudicial and it's not related to anybody testifying, and I'm excluding that. All right, now what is this video about? Okay, everyone can have a seat. What is this about? Everybody say, all right, just before we bring the witness, the parties had a chance to think about what to discuss. I prepared a rule on it, Your Honor. Before you rule, might be an opportunity to brief it. Well, I don't think anything's coming in today. Nothing is coming in today. I will tell you what I'm thinking about, just so I don't have to surprise anyone. Sure, I think the first video is clearly relevant to come to Anna, witness Anna. The second one, however, is cumulative because I think, do you still need to brief, or do you want to snatch defeat from the jaws of victory? Let me find out from Mr. Scholar which is the first and which is the second. Okay, speak to him about that. But only caveat is that the caveat with everything is that there is some suggestion that I cannot imagine what it could be. But if there's some suggestion that it did not happen or some way that the door gets open, yes. But I think that the evidence as it relates to the victim, the witness who is going to testify, is clearly relevant not only to what her own experience was, but the experience was of one of the witnesses, specifically Jane, who testified. And I mean, I think it is fair to say that for a lot of people, including me, it is very difficult to imagine that some people would engage in this kind of conduct. And so the evidence of it is relevant. And so my ruling is, and if you still want to brief it, you can. Thank you, Your Honor. Okay, I guess you could brief it too. Oh, right. I was planning to offer it now, though. I am not going to publish it. I mean, I don't think it should come into evidence. So I am. Okay, wait a minute. No, I'm sorry. I was going to offer the one involving Anna. The court says, yes, it can be offered into evidence. It is not going to be played right now. That's right. There is no problem with that. I'm just thinking about it, Your Honor. Turn on your, because the witness is here now, so I don't think there is any dispute that the evidence is on the defendant's computer. Yes, I understand, Your Honor. I understand perfectly. All right, and so that the part of the foundation has been established through or will be established through the witness. I was just a little confused because I didn't know who Anna was. I see. Do you know now? I know now. Yes. Okay. I think we are all on the same page. Shall we get anything else before the witness? Yeah, Becker. I'm sorry, Judge. Can we also brief the other issue with regards to the introduction of some videos that involve, my understanding is this was talked about at a sidebar as well, or no? That is what we're just talking about. No, I think not those videos, Judge. That's Becker. There are additional videos that we within that list that we seek to offer right now, which were not raised before Your Honor at the last sidebar. Well, are those similar to what they are not the same as. Yes, they're not the same. Do they involve people who are testifying or conduct that is at issue? There is conduct that's an issue. Okay. And yes, people who are testifying as well. Oh, we might got something. Mr. Scarlett. Yes, Judge. Can you get those? Can you get a microphone? Yes. Thanks very much. You can sit down if it's easier. Sure, Judge. Thank you. Judge, these are videos that the government wants to emit through the witness that may involve three people, right? And there has been testimony about that. And I understand, Judge. I know you're ruled on that previously. However, was there an objection to it, Ms. Scarlett? Yes, there was an objection. I believe the government said that they were going to play snippets. First, we wanted to know what snippets they were intending to play. Well, nobody is playing anything today. That's correct. And as I understand it, and I could really be wrong on this because there were a number of motions in limine. I don't recall any specific motions in limine. God damn it. About video evidence. Wait a minute. I'm getting somewhere. Hold on. This goddamn. Hold on, y'all. Okay, about video evidence. And correct me if I'm wrong about that. I just do not recall that there was a motion to preclude anything. So I'm a little bit in the dark about some of the things that we're talking about. What I would suggest is, as I said with respect to the other evidence, this is the this is the this is a foundational witness who you probably could have stipulated to that he recovered this laptop or whatever it is. And I do not think there is any real dispute that this stuff is on there. So the question is, which of it comes into evidence? We see we walking the shit down. And we gonna find the motherfucker over here. Okay, I have made my ruling. So you can try to persuade me that I am wrong, but and remember I say these briefs, the filings and all this stuff, they are persuading briefs, right? Persuading arguments, right? Just written out. Persuade me that I'm wrong about the one that we talked about at the side. There is no application before me on the other ones unless you are making one now. Scholar, judge, we would make one now with respect to the court, but I do not know what you are asking because I would need to identify what the videos are and to whom they relate. There has clearly been testimony by multiple witnesses that one of the features of their time with the defendant was that he was taping things on a pretty constant basis. Okay, what is this? Okay. And so they are clearly relevant to that testimony. Okay. But again, I am just speaking generally here because of what has been presented to me. This isn't something that anybody litigated before. So the witness is here. I am trying to move the trial along a little bit. My suggestion is that he can testify to what is on there, and then we can have a conversation about which of the videos comes in. But I would have been happier to have this conversation before now. Understood, Judge. So why don't we proceed that way? Nobody's playing anything today, as far as I understand. And so I don't know. I think, why don't we finish the witness who comes after this? By the way, we have a witness who is en route, and I believe she will be next, and her name is Alexis. Okay, but no videos related to Alexis, correct? No videos are related to Alexis. I just want to know from the government. They said she is en route. Is she on the ground? Yes, blah, blah, blah. She's in the Bronx River Parkway. Kidding. Shall We get the witness, get yes. Just to be clear, my team has corrected me. There are videos, but not that type of video. Okay, all right, go ahead. You can have a seat until get your all right. And welcome back. Okay, before breakfast lunch, I showed you a series of exhibits. Okay, do you recall the exhibit? Yes. And those exhibits reflect partial examination reports from your forensic examination government 345, which was an iPad that introduced into evidence early. Yes. Yes, at this time the government offered that motion. And I am showing witness what's been marked for identification through 7, which already is in evidence. Do you recognize that? Yeah. And those are your initials there. Yeah. And have you had the opportunity to review? Yeah. Are those videos that were from government recovered on government's exhibits 2.7? Yes. And now I am showing just the witness what has been marked for identification 328. Do you recognize that? And it's a CD containing videos as well. And where those videos are recovered from the iPad, which the evidence government's exhibit to us, and yes, were recovered from the defendant's residence. Correct. This is from his residence. And these here, your initials here, yes. Guess at this point the government offered all of that and all of that. The subject to the discussion that those are admissible. They were receiving evidence. Thank you, Your Honor. Okay, I'm going to provide my person, Your Honor. I'm going to provide witness and be published to the jury only. This did you recognize a photograph? Yeah, these are photographs that were found on the defendant on the iPad that was seized from the defendant's residence in evidence government 3.7. Yes, they were. And if you were referring to what's in front of you, government 3.6, I want to direct your attention to image 1914. Do you see that? Yes. And I believe the correspondence with shown in 326. Is that correct? Yes, it does. And are you able to see from looking at 326 when that particular photograph was taken? Yes, in January 18th. Are you able to determine what was taken with Apple iPad Pro? And there are a series of photographs of individuals, same attire, with also taken January 14th, and specifically directing your attention to image. Yes. And were each of those images of photographs taken January? Yeah. And we'll take them on iPads. Yes. Da, da, da. And I refer to the images is that it file name in particular order. That's the default name of the mentioned Apple products. Okay. Okay. And shown again the jury, photograph, they determine the device. Okay. And going to break for a minute. I'm sorry. Okay. So that usually happens when they're showing a video and those thumbnails from the video showing segments of it. Right. A particular file identified file image 1930s move, right? Yeah. Is videos featured on the government re- received the government, are you able to generate and are you able to use it with Apple Pro? Could you see the parties? Okay, sidebar. I just want to clarify that these are thumbnails of some videos. So what's going on? What's going on? These two videos are in evidence from yesterday. I'm going to show the thumbnails and question. Get to it. Do you object to the counsel? So no. Rather going through each one is riveting. Okay, it is riveting. Wait a minute. I understand it is riveting. If there is a way to do it, if they do not object to the dates, it might move things along if your witness needs more time to get here. She's literally just walked in. Okay. Just to say, I mean, this is fine. The group. Yes, they listed a bit differently, but I'll do my best. Just to think, and nobody's disputing for no reason. I'm not disputing, and Skylar's not disputing. Just get to what's on there. And you have testified about the creation date of several video of photographs and now two videos. And on the examination of reports, you you have seen both create one video that says creation date, blah 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 blah. This must be an Apple iPad. This must be Apple, the Apple do it or something. Cause yeah, it's got to be Apple tech or something. And this created a date which photograph video was taken by a particular and the The create then is located. I just want to make sure that I have misspoken. All right, just looking at the government exhibit 227 against my fingers pointed where something says that the creation date goes to say UTC. And then there's another credit. Okay. What's on the damn shit? Okay, and at least with respect to this video, where to create. Okay, all right. Establishing chain because I got that. Cross examination, a few minutes. What's on the tapes? Let's go out, everybody. I think. So you know what, y'all? I believe. See that that book of evidence that was from his house. So 327 was from his house, not from the storage. That's from his house. Okay, this who is this? Alexis. What Jacksonville? I get nervous when I see Jacksonville. And I'm a registered nurse. And where were you raised in? Was it Jacksonville? Hey, so this dude that I met the other day, he called Jacksonville Jackson Kill. Ain't that some shit? I drive over there, got my GED. Alexis. Who's Alexis? I'm showing defendant Kelly in court. Okay, he's on Bluetooth. Okay. All right. So I think that the bulk of that okay. 327 is from his house. Okay, let's get this story. The defendant. Let's get to that. Okay. Continue, listen, the defendant Robert had leased in storage facility. Okay, and continue in paragraph 2C. Okay, and continue on paragraph 2C of the same stipulation. And it reads, on January 9, 2020, I saw law enforcement agent conduct the storage. Okay, the storage facility. Okay, during the storage facility, 2 iPads and multiple. Here we get into the nitty gritty. Ain't y'all private eye gonna figure it out. Storage. They telling me right there. They said 2 iPads, multiple phones were recovered, including an iPhone containing government exhibit GE 481 and 482. Also during the oh shit, I went too far. I think it happened. Hold on. Okay. Okay. Storage facility. Multiple hard drives were recovered, including hard drives containing government exhibit 468, 469, 70. I have to find this for myself. 472, 473. Now remove. Okay. Those are the hard drives. Now, during the search of the storage facility January 9th, was the black backpack. There's a backpack. So y'all ain't tell me nothing about all this shit. I'm sorry. Book bag was covered during the temperature. Searching. Okay. And at this time, the government officer exhibits 902 to we there's an objection. Any objection? No. Not to receiving evidence. We distribute transcript binders and ask the jury if they could tab each one. Okay, they had Okay, Ryan Chabot, you have one in front of you, Miss Kidd. Okay. Okay, we're now going to play for the jury with some evidence. Part of it was not evidence. Exhibit 902, please. Video. This is certified report record from BT. Okay. Now, what is this? Did you recall what's going? Yeah, defend Mr. Kelly. Okay, objection. Now I'm receiving evidence. I'm putting, which is AJ number, because this is some legal stuff. Government. Okay, hold on. Okay. Okay, and there were several FedEx envelopes on okay. So, okay, E, that's Nike. Okay. And the government shown witnesses proximity between Nike. Okay. What is this he recovered? Was was not present. This is about Aaliyah. Okay. I don't know nothing about all this now. Okay, I'm just government. Okay, Sean and the Google and show two Google ladies. Okay, government exhibits. Oh, all right. Okay, the government offers exhibits. Okay, and I just meant. Okay, okay, those items recovered. Did you obtain them the same store? Yes, for the same one. And again, 4 or 5 at the top of it indicates chocolate factory. Envelope states okay. And the time cards, because time cards for people. All right. And okay, wait a minute. What numbers are those? 4 or 5? Did I write 4 or 5? Oh, so that's something different. Um, okay. And FedEx found there's several. Okay. And telephone and okay, so led to label old messages. Written old messages. Okay, testified that early. Yeah. Okay. So 466. Okay. Okay. Okay, so Exhibit 210 as well as other calls, those entered into evidence which were present. But when they entered into evidence, can you tell us what was the income call, outcome call? I cannot. Okay, okay, evidence. Okay, beginning of evidence. You had to my yes. Okay, and from these several phone calls and messages. Okay, these are the messages from Juice now. Okay, that's my video. Okay, and another example of an envelope recovered from a defendant's storage facility. Yes. Indicate messages. Is that right? Yes. Okay, these are additional phone messages. Okay, this is phone messages from storage. All right. Goddamn, that storage was huge. It was huge for this case. Okay, when Exhibit 4, what does it indicate? It recovered from the storage unit, and there was safe within the storage unit, and what was in the safe. Okay, now paragraph. Tell you to read part referring to the search and storage and the album. This in Government Day 481 documents and other items. What's in that? Okay. Shown was the government report from the lock safe. So the document protector, the storage is from safe protector. Protectors within the storage facility. Okay, the recovery from storage unit was one of those. Okay, the storage was conducted and was able to access contents of the safe. And storage an iPhone containing exhibit. The safe was sealed within, and there was recovered. And there was recovered. Did include document protector, plus some kind of paperwork, document protectors. Okay, so I'm almost done, y'all. Generally speaking, where there were 3 exhibits. I'm sorry. Recovered from the safe inside the Kentwood and Kent Avenue. I'm sorry. Published briefly. It appears to be purported Lexington Nurse home ID for Geronis's paperwork. And when the government exhibits were found in the safe, there was actual documents. Okay, that's documents. Okay, safe within the storage were found. What was found there? Uh, Actual documents. Okay. Where the government found, okay, and evidence was given. Um, okay, at the bottom of the brief, but did not identify testifying here in the trial. What was this? Um, All right. Okay. All right. I know I have been all over the place messing up multiple places, not following instructions, being goofy. But those the letters. What is this? Read the whole thing. That's the letter. Okay, the government wrote found was an evidence. That's the letter. Okay, that's the letter. Okay, okay, okay. Which was found evidence, which were this. I don't know if that's what it is, but this case at all. So it's 400. Okay, there. Okay, items that are in 400s. Okay, I don't know if you testified this yesterday, but it is in the case that all of the items that are in the 400s are recovered from the storage unit. Yes, Your Honor. And all of the ones that are 300, those are from the Trump Tower. So the 400s is from the storage, okay, which I already got down. 400 is the storage, 300 is from Trump. Okay, all right. Child, this peon work I'm doing here. Peon work. This work you sign out. That's for somebody else to do. Shit. Okay. All right. So the objection is sustained. Where the phone was recovered from, exhibit. That's the story. Because the phone, that's a phone in storage unit. Okay, I'm showing you, which is in evidence, which is this text messages on some kind of phone. Okay, now there was recovered. Good. All right, here was some. There were recovered because the videos were recovered from the storage unit. Is that correct? All right, hold on. Let me go back up. Okay. The government offers 343B with screenshots of redactions from a video that was just played. No, okay. Those are in evidence. Government, okay. These were recovered because the videos were recovered from the storage unit. Is that correct? It's in the 300s. It's in the 300s. Getty said. The court says the 400s. Getty said no. The next one is 342, 341, 2, and 3 were recovered from the residence, and the 400s are all. And Getty says from the storage facility. Yes, and the court says okay. And if anyone could just turn their headphones on, we're about to put them on again. The government now offers government exhibit 484, okay, which is a transcript, probably the transcript of a video. So is it admitted? Yes, Your Honor. And Your Honor, that's with our exception. Hold on. Okay, the unit. Okay, what is it? Okay. VHS tapes. I'm getting close. All right. Okay. So we're going to move the agent and direct your attention to the line for the okay. The government exhibit 484, which is an evidence on the screen for the jury only. That must be a tape. Get what's they recovered from the storage unit. Is that a VHS tape? It is. Where was government exhibit 484? The storage unit. And was we just listened to 484A? Was that just an excerpt? And what shown in government exhibit 44? Yes. I'm sorry, I said 44A, but I mean it was 44B excerpt. And what was contained on the VHS tape shown in 484? Okay, the government. Okay, they put 485 on the screen. Okay, for it was just conserved. For the government now offers 45. Court objection. No, Ms. Kim, 1 second, please. I'm sure the just excerpt from that area. The items and evidence. The government exhibits 485B. It would tell you the use of the transcripts in my final instructions, but suffice to say there are aid in listening to the evidence. Okay, so remember I just said the transcript of what they're looking at. Okay, and 45. So I should have did the transcript. Hell, I wouldn't know what the hell's going on. And 45, I'm putting on the screen. My lazy ass. Where was 45 found in the storage? And I put 45A. If that's the manner in which it was found in storage, yes. And I'm going to go on the backside of it. It has Chocolate Factory, 3 years, 280, and 3 tracks, says 3A, and I'm not going to play. And it's one of those tracks. One of the 3 tracks containing the government exhibit 485. Yes, Miss Guess, and this is just audio, so you don't need to look at your screen at the audio. It's approximately an hour and 20 minutes. We're not going to listen to the full hour and 20 minutes, but if I can direct everybody's attention to the tab number, we're going to play starting from a minute, approximately 25 minutes. So if anyone could put their headsets on and raise your hand if anyone have any issues during recording. And okay, is there a reason why you can't just play it over the guess it identifies someone by name, but we could probably do it. It's fine. Why don't you try that? Okay, let's start from the beginning. Everyone take off your headphones. In the transcript, there's ellipses, so not every word is transcribed, but I think the gist is here. We will start at 110. Before I start, Agent Chabot, review this recording correct. Do you recognize the male voice predominantly speak throughout? I do. Who you recognize to be the defendants? And the transcript is there. As noted on the first page, sometimes it indicates IU. That refers to an unintelligible, I can never say it right, illegible. Okay, illegible shit. It's not legible shit. And when you see the 3 dots, that indicates that there are some parts that are not transcribing for. Okay, so if we can start there 110, everyone take their headphones. The difficulties, we're going to stop. This part of the play, the general alternate. Okay, 10-20 minutes. Okay. And you testify to say it was in a storage unit and you never saw. Okay. If only this is storage, I don't know, sir. Okay. Yes. Who is Holder? Okay. Independent storage stop correct. Independent storage store facility. So, and how are you able to access? Okay. Outside the storage. Correct. In your screen, you see 2 emails that were recovered from a computer with independent storage. This is government exhibit 468, and one is an email referring to Brenton. Alexis to be picked up, and again, Alexis 17. Okay, as you saw the typewritten numbers on that were found in independent storage facility. This is shown in government's 401. These 3 little slips of paper for a phone number, and then 7283. And you see from the government exhibit that phone number, it says subscribe. The defendant business RSK Enterprise. Okay. And you learn how the defendant kept those letters. That okay. This is paperwork. Actually, see paperwork. Canon. Okay. Oh, wait a minute. Canon is I need to get my ass up. I'm coming, y'all. Hold on. Okay, again, it says storage facility, like safe storage facility, and confessing to stealing. That's okay. The phone was taken from storage facility. Text message. Safe for years. DNA. Prescription call. Okay. Okay, I don't went through that whole document. Okay. So, maybe, sorry, y'all. I didn't make y'all go through that. Maybe the tapes or whatever it was, because look like the storage stuff was in the 400s, evidence in the 400s, right? From the storage. And look like to me that was primarily phone messages and shit like that. So if that's the case, then hmm, I don't know if those tapes, if all of that is going to show up in Chicago. It might, but you would have to think that it would probably. Now you see that uncharged acts, most likely, it may or may not. If some uncharged acts shows up in Chicago, then probably some tapes may show up. If some tapes that was found in that damn storage, oh, you know what? You know what's a good way to test that? That indictment has had those minors 1 through 6 since 2019, right? They hadn't had a different. They've always had 6 minors or 5 or 6 minors or whatever it is, right? If anything from Chicago, any tapes from the storage would have been added, it would have been superseded to probably add some additional people. Because the storage was captured in 2020. The indictment has already had its charged acts 1 through 6. I don't know how many people's 5 or 6 of them prior to 2020, and it has not changed. It has not increased. Had it increased, then that would probably say that them videos, was maybe a culprit for it increasing. But also, somebody bring their ass in and saying, yeah, I was videotaped. Of course, I told you testimony is evidence as well. Unless those uncharged acts, right now, it don't look like there are any, which would, be other people. But if they had video to come in, and it was somebody that they could, that they, was able to turn into a victim witness and shit, that indictment would have been superseded. Those videos would have been added. We still dealing with the same videos. Hmm. Mm. And it could be that they processed the storage. Nobody wanted to be bothered, and you know, what I'm saying. It could have very well been some um, child porn or whatever. But if not, if those videos were as such, you know, it seemed like it would have been entered into evidence in that 400 series as we uncovered, right? I don't know. We're gonna see. We're gonna see. That's gonna be goddamn mystery. But y'all, was there a sex tape? Somebody said it was one. I thought I have no idea. That's what I was trying to go through and find, right? Because it seems like it would have been contained in that 400 series from the storage. And then we do know that there was a 300 series that was confiscated from the Trump Towers. And just because and I'm not saying the 400 and the 300 all were videos. No, as you can see, it was phone messages and letters and all kinds of bullshit, right? So, no, y'all. I don't know, but I want to say, and I'm just not sure, because I stood my ground on last time about them damn tapes. I was right. So, and we didn't see a motion in limine where somebody where they were we don't see anything about uncharged acts yet. We didn't see anything about somebody disputing some more tapes because Jabo would know it now. She would know it by now that there are some more tapes because of being discovered. We might not know, but she would know. And they would be probably submitting something to get the identities of the people on the tapes that we don't know nothing about. It'll be some kind of paperwork that would tell us that it's some more tapes that we don't know about. So, I don't know. We pretty good over here. So, I don't know, y'all. But yeah, we just went dumpster diving. And that's how that works. So, give me just 1 minute. Let me see if my script in 1 minute. Okay, I got some more time. Sorry about that, y'all. Sorry about that. So, what y'all think? What do y'all think? What do y'all think? See, like before, right? I do process of elimination because I know the process, right? To determine, you know, all these video, all these 100 devices, where they're gonna, where they're gonna show up. So that's why I was kind of strong about them not being in New York because of certain factors, certain circumstances never happened, right? It didn't happen in a specified amount of time. Plus, when one of those motion and limited came through, and they said that they didn't have any video evidence. I think it was Jane number 4 and 5, I believe. It was two of them. I was like, wait a minute, right? And then they said, and then when the government came back and said, well, if the defense thinks that testimony about the videos isn't evidence, he is wrong. I was like, okay. So that tells me that the government is saying that they just got testimony about the videos. So now we walking it down. That's how you do process elimination, right? With this legal shit. So now this is the four. We don't have a superseding indictment. By the way, what I just read earlier, the government says that it does not seek to introduce uncharged acts about abuse. Well, and I told you, if I'm not mistaken, right? Isn't the charge? Hold on, let me look. I got some time with you. I got some time with you. Let me see. Hold on. Let me see what his charge. So I don't remember this shit. Like this shit don't stay on my damn mind. Let me see what his actual charges. If his actual charges are sexual abuse, then I sure appreciate y'all hanging out with me. Please like, share, and subscribe, and hit that like button. Because that means you like me coming on here to do this type of shit. See, y'all damn near paralegals now. Hell, I know Cotton Candy in the chat. I know Karen. She on the way to being damn first chair. Not first chair. I mean, a 1L, honey, first year law student. That got to be the case. So hold on, I put up New York. We walks this shit down. See, a lot of people get this shit wrong. They don't never come back out and say, "Oh, I was wrong," whatever. They just let the incorrect information go by, right? Like, you ain't, uh, uh. Okay, so he was charged with count one is what is count one? What is that? Is that sexual abuse? Okay, well, that's count one is a video. Count two is a video, so probably sexual abuse. Count three is some kind of video that's probably sexual abuse. Count four is probably sexual abuse. Okay. So we got sexual abuses, we got conspiracy, And we have even if it's probably not child pornography. Even if it was child pornography, we still good because they're talking about abuse, right? It's physical abuse. I think physical abuse may be mentioned. I don't know if it's a focal point. But like I said, physical abuse can be wrapped up in the charge of sexual abuse. They said they don't intend to um, put in uncharged acts for abuse. His charges are, I think, it's sexual abuse. I'm pretty sure. Sexual abuse and conspiracy. Hold on. Count seven is, see, all that's about the, okay, what count nine is. Count nine is, hold on, okay, 18 USC 2422. Hold on. A coercion and enticement. All right. Okay. We walking this shit down. All right. What is that first charge? What's that first charge? 2251. Sexual exploitation. Okay. So we got sexual exploitation. Let me see what sexual exploitation can cover. Hold on. Any engage in transport to producing. Okay, all of that is the video shit. That's the video shit. Be Pentagon having custom minor section support to reducing video depict. All this shit is video depiction shit. Okay, so this gets better. Now we getting a clear cut picture. They say they don't intend to introduce anything about abuse. This all has to do with, okay, so you know what? Some videos might show up. Some videos might show up because they say they don't intend to introduce anything about abuse. They got sexual exploitation. Those are the videos. That's AKA the child pornography. Okay, that's what he was charged with before. This is sexual exploitation. Slightly different, but it encompasses the child pornography and uh, going across the state lines and all that other bullshit that they wrote up, right? So, what is it? What do they have for sexual abuse? What's federal sexual abuse? Hold on. We're gonna walk this shit down tonight. Cause I got time to spend with you tonight. I ain't had this much time in a minute. Um, sexual abuse is 18, 2244 and 2245. Wait a minute. What about other minor? Hold on. 2243. So that's in the 2243s, 44s, and 45. That's your abuses. Your abuses are 2243 to 45, maybe 46. Something resulting in a death is something greater than that number. So we have, so we don't have any twenty-two 43 to 2245. So there is a chance that some videos may show up. So they're not doing 2243s on uncharged there, but I don't know why it hasn't been superseded. I don't know. Do they plan to bring it in as an uncharged act? So they may show up in Chicago. They may show up in Chicago. So we're gonna leave that open. Then we walk that shit down. They may show up in Chicago. Because your abuse code is your exploitation, I'm sorry, is the 2251s. And the other one I said, I mean your I'm sorry, your sexual exploitation. Your abuses are 2243s for of a minor. So videos may some more shit may show up. Don't know. I'm speculating that if it hadn't shown up by now, that it won't. But you never know, because the government, see, that is already in discovery. And they're saying they're not going to do anything about abuse. They didn't say they're not doing any uncharged acts about sexual exploitation. They didn't say that. They didn't say that. But if they were doing, well, now you got time to filings now. If they were doing uncharged acts about that, those last motion and limits in New York came in on the 23rd of July, and the case started. So this 14 days, 11, this less than 15 days. That motion and limit I think it's 30 days. It should have been in for uncharged acts to be added, and everybody are, they're in the period now. They've submitted their motion and limit. Not now, unless the government will file something to file a motion to go outside the normal procedure to add the uncharged acts, then yeah, but I'm pretty sure Von Jean will scream that just adding that so close to opening day. I don't know. Like I said, the government can file to, if it's outside of, it's beyond the time, the filing period. They could ask the judge for leave, to file outside of. That's what it means when you leave. You're doing something outside the normal procedure of the court to file, paperwork. So I don't know. Y'all. Oh no, but this is how we get down to our exactness over here. That's how we be, on point. Yeah. We just have to watch that. They could hit us across the head tonight. Shit. With When we sleep, here comes some paperwork. So I don't know. It looks like the government is set with their case, what they have. I think they're probably saying that they're going to go with what they already have. So, but anyway, y'all, I am sorry to hold y'all. I'm going to end it on a straight up 5 hours. Let me see if I can. Oh, thank you, Alvaro. Oh, you so sweet. Oh, that was so sweet to me today. Hey, Samantha Nicole. Let me holler at some more people. Hey, Just My Thoughts. Thank y'all for engaging in that chat. Got caught candy. Hey, stop lying. What you said, Miss Angie? You and I never had a problem. What was my question to you taking down? What question? Stop lying. I didn't take a question down tonight, or was it on the board? Because YouTube be doing fooling up with the questions and stuff. If you left a question on the board and you didn't see it, sometimes YouTube move it in the private. I don't want to call it private comments, but you don't see it until I go in there and look at it and release it. I haven't been in there in a couple weeks. You can go ahead and post it again. Dynamite. Progress 2 times. Lady T, I think I got the rest of y'all. Yeah, go ahead and repost it. I'm sorry, I just looked up. If you're still in here, I'll go back and check it. I haven't been in that damn thing in a minute. I really haven't. I got on top of it. It's like cleaning out your mailbox. I was getting on top of it. I got it. Oh my gosh. I want to tell you, it took hours one day. I was like, hell no. And I just sat up and did it. And then I hope it ain't piled back up in there. No, but it don't be, sometimes it be YouTube or whatever taking it down or whatever, and you can never tell what it finds, what YouTube finds, offensive or whatever. Because I'll sometimes look at a question that they don't moved it in the back or whatever, pending for review. I'm like, what is this? Oh, you're welcome, honey. You're welcome. You're welcome. You're welcome. We covered a lot today, baby. We had to break down. Judge Linen man, you see how he do his damn paperwork, y'all. Judge Ann has the sweetest. Well, I ain't want let's not talk shit because they watch. But Judge Ann has the form, and she handles things, issue by issue by issue. Lennon Weber, he grouped the shit all together. He has the damn shit like he writing in APA, MLA style and shit. Instead of, like a nice legal form and shit. He's like, It's great. It's like he does like 1+1 and then have your little line, then equals, you got 2 up under that. Instead of, Judge Ann has her, the issue, the objection. We're talking legal, the objection, and then her explanation, and she moves on. She has, her Roman numerals and all of that. Child, he put on there. Just let him wherever ghetto. He got all the people motions on there. He done answered Browns, J Bowles, and the goddamn government all in one filing on the same. I'm like, God damn. Like, damn. Man, oh my goodness. Like, how old are you, sir? When are you going to retire? You ain't even doing it cute like Judge Ann. Damn. I knew he was going to damn run me crazy. I knew it. He got it all on the same paper, on the same file. He don't care. And he's so, and I noticed early on that he was so, that day I was reading something and he ended it so abruptly. I'm like, oh, that's how he ends stuff? Not even you know, some fluff on it. He'd be like, it's denied. And keep it moving. Like, damn. That's crazy though. But y'all, I'm gonna get on out of here. Make sure y'all like, share, and subscribe. So thanks again to the panelists, the hostess, the guests, and everybody else. Till the next live. There's another one in the books. I got to go, honey, and go fucking lawn jumping and shit. Cause I got to holler. I'm gonna laugh if Sylvia's over there telling y'all about y'all ass. I hope I catch a couple other breakdowns that I like to listen to. But anyway, I appreciate y'all. Love y'all. Peace out. I ended it up a lot better, so I got that shit off my chest than I started. But anyway, y'all always keeps me what? In a good place. I like coming on now. Anyway, even though I like coming on now I took on goddamn jobs and shit. I can't hardly come on like I want to come on. But I like coming on now. But all right, y'all. Pieces. I will. Not pieces. Oh, Lord. I didn't mean to say pieces. Child, the girl was I'm stealing shit. No, I mean peace. I mean peace, okay? To the next live. There's another one in the books. Love y'all. Bye, y'all.